going to go and call this meeting to order. Time is 8:30. I will ask Dr. Weston to lead us in invocation. If you'd like to join, you're welcome to.
Dear Heavenly Father, thank you for all the blessings you give us each and every day and for this great country. As we meet here today to do the work of this state, help us to listen and make the decisions that are right for the Commission and the people of Texas that work all throughout the state. In your name we pray. Amen.
Amen.
Tamala, will you please call roll?
Chairman Rick Figueroa,
Here.
Vice Chairman Tom Butler, Dr. Ray Callis,
Here.
Commissioner Helen Collier, Commissioner Nora Castaneda,
Here.
Commissioner Joel Garza,
Here.
Dr. Gary Wesson.
Here.
You have a quorum.
Thank you. I wanted to take a little personal privilege. If nothing, at TDLR, in the years that I've been here, I've realized that we're a family. Sometimes we get lost in the legalities, the regulations, the nuances of what we do. But all that doesn't matter because we're all humans. And as humanities, the relationships, I believe, are what the currency of heaven is. And our family's taken a hit of late. And I wanted to take a moment, first of all, to recognize those that we've lost, but also to acknowledge the preciousness of us and each of us and how we interact with each other. The three of us, Saeed Nagbeek, Shane Hawkins, and Georgetta Collins, who were taken way too soon. But I just wanted to take a minute, to say two important things. One is they'll be missed. There's no replacement these wonderful people. But two, we move on to honor them and to honor them how we do our job and what we do and how we serve the people. They wouldn't expect anything less of us, and we wouldn't expect anything less of them. So I'm going to take a moment of silence. Thank you. Okay, so we're going to move on to item D, public comment. If you're here for the Barber or Cosmetology, I'm going to ask you to defer till we get to item L and M. So is there anyone here wishing to address the commission on a matter that is not on the agenda? If you are here to speak on a contested case, you'll be called up when that case gets on the agenda. If you want to speak to fill a public comment form, turn it in. And you have 3 minutes. Our general counsel will keep time. You understand the commission is not allowed to ask any questions or engage in discussion with you about anything that's specific on our agenda. Okay, so I think most of the public, Tamala, most of the public comments except for Mr. Burke is, okay, Doug Burks.
Thank you, Mr. Chair.
Yes,
Commissioners.
Go ahead and have a seat.
Thank you very much.
Make sure you state your name, please.
Yes, sir. Doug Burks.
You got 3 minutes, and we
Okay.
can't engage you.
Yes, sir.
Okay, great.
Absolutely. My name is Doug Burks. I'm the Environmental Project Manager with the West Central Texas Council of Governments out of Abilene. I'm also a Code Enforcement Officer. Council of Governments in Abilene. We are a governmental entity, and we administer state and federal programs within a 19-county region that we have up there. Given the geographic location of where the Council of Governments is in Abilene, and the small rural communities that have limited budgets, it's quite a hardship for small West Texas towns to hire and send a code enforcement officer candidate for a week-long training to some of the bigger cities such as Austin, San Antonio, Houston, El Paso. And that's kind of where, in our region, that's where we have to send our code enforcement officers for the training. Also, it runs an average of about $1,500 to $2,000 to send a code enforcement officer candidate to one of these classes, which is a 36-hour course. So what we're asking that the Council of Governments in Abilene, if we could become a provider for the basic code enforcement officer licensing. We do understand that TEEX has that right now under RAPS, Texas A&M Extension Service, Engineering Extension Service, and they're kind of the sole source provider of the course in the state of Texas. And I haven't really found anything or located anything that says that they're the only ones that can provide this course. But we're going to ask if we can get on the agenda for your next meeting and see if we can come before you and speak to you about this and see if we can move forward with becoming a certified provider for this curriculum in our area.
Mr. Burks, thank you appreciate that.
Thank you very much.
Mr. Chairman, Brian Francis, we will reach out to Mr. Burks before the meeting's done, and we may try to save him a moment of coming back to the commission since he'll probably need to handle that at the department level, but we'll definitely.
That'd be
deal
great.
with him. Okay.
We'll break into executive session. You may.
I appreciate it.
All right. Any other comments, Cameron? Okay.
Mr. Chairman, Brian Francis, one more time. If we could accept some excused absences for the members that are not present.
Yes.
Thank you.
Yes, actually, I'm passing that around right now. So we should. So is there a motion to accept excused absences?
Make a motion to accept.
Second.
All in favor?
Aye.
All right, carries. All right, so we are going to go into executive session to consult with our attorney under section 551.071, section 1, and 551.071, section 2, government code. The time is 8:37. Time is 9:06, and we've concluded our executive session. We're going to move on to item E. We're going to look at the minutes. Commissioners, any comments about the minutes?
Make a motion to approve the minutes.
Is there a second?
Second.
All in favor?
Aye.
Motion carries. On to item H, training for commissioners. Brad? You got
Mr.
13
Chairman?
minutes, sir.
Did you want us to go ahead with this item now?
Yes, you got
Okay.
13 minutes.
Okay.
I'm keeping
my-
time on you, too.
Okay, I have got a couple of very important folks coming up.
Are you stalling?
I am stalling a
Good
little
job
bit.
stalling, sir.
Uh,
Well done, sir.
Mia Settle is our open records attorney here at TDLR, and Molly Fudel is an assistant general counsel who has helped out quite a bit in open records. And they're going to update the commission on some changes in the law in the Public Information Act that impact really all public servants and how you handle information. And it's something that we thought that the commission really needs to be aware of. And also just a time for a refresher on Public Information Act. So we will briefly cover that issue for you.
Outstanding. Thank you, Brad. Good morning.
Good morning. My name is Molly Fudel. I'm an Assistant General Counsel here with the department, and I'll go ahead and introduce my colleague, Mia Settle.
My name is Mia Settle. I'm the Open Records Attorney and lead for the Open Records team.
Thank you both for being here.
I'm going to talk to you about some legislative updates, but first, Mia is going to give you some background on the Public Information Act.
Good morning. I want to start by stating what a privilege it is for me to be here before you for the very first time to present this brief Open Records overview as a foundation for the legislative update that will immediately follow and be presented by my colleague, Molly Fudel. As many of you know, the Open Records team is charged with the responsibility of ensuring that the department complies with all Open Records provisions. And the Open Records team processes thousands of requests every fiscal year. And with each request and everything we do, our agency core values are at the center as our guiding principles, including integrity, accountability, customer service, and open communications. And with those same core values in mind, I'm sure we can all agree that one of the most significant aspects of what we do as a governmental body is to conduct our business in an open and transparent manner. Well, the Texas Public Information Act, or the Open Records Act, which can be found in Chapter 552 of the Texas Government Code, is one of the most dynamic means by which we can and we do accomplish transparency, because it allows citizens to access records that we maintain so that they can gain insight into our operations. And because I'm having to run this a little short, I do want to state that the Open Records Act pretty much mandates every step in the process of responding to an open records request, from how a request is received, of course you probably already know, to how much time we have to respond to a request, and even setting up a general rule that requires us to approach a request as if we're presuming that the information is open that the person is asking for. Also, you also probably know what a record is. It's a pretty broad definition there. It's any and all records that we create, collect, assemble, or maintain. And also, I'm going to skip over a lot of things here. It includes electronic communications, and that includes instant messages, emails, and text messages, including those text messages or those electronic communications on your personal devices. And I'm not going to go into that in great detail because my colleague Molly Fudel will cover that when she covers Senate Bill 944 during the legislative update portion. Also, in addition to setting up a general rule, we all know that wherever there's a general rule, there's going to be exceptions. And under the Public Information Act, there are hundreds of them. And luckily, you don't have to be well-versed in those because the Open Records team is. And so with that, those cut out the pie in the big general rule. And so with that, I'm going to leave you with some takeaways. One is if you receive a request, please forward it to us as soon as possible because we do have 10 business days maximum to respond to a request. Also, if you receive a request from us in Open Records or anyone in General Counsel for records that you may have, please respond promptly. I think you all have experienced that before and you have done so, and we appreciate that. And last but not least, if you have not already done so, we encourage you to view the Open Records training video that is available on the Office of the Attorney General's website. I believe the link is included in your briefing material and on the last page of this presentation, along with other Open Records resources. And with that, I'm available for any questions. I know that was quick. I was told to be quick, so.
Great job. Thank you.
Thank you.
All right, thank you. So now I'll get into the legislative updates. So the main update this legislative session is from SB 944, and it says essentially if you have public information on a private device or account, so your personal cell phone or a private email account, you are considered a temporary custodian of that information. And as a temporary custodian, you have a responsibility to either forward that information to the agency servers, or maintain it yourself in its original form in a backup or archive and on your private device for as long as is required by the agency's retention schedule. Clearly, nobody wants to do that, so we're going to give you some tips on how to comply and how to move it to TDLR servers instead. I want to also clarify that this responsibility exists even if we never get a request for the information that you have. You still have that responsibility to transfer it to the agency servers. Also, just a reminder that there is a criminal penalty of monetary fine or jail time or both for destroying or removing public information. So these are the best practices, the tips that I was talking about for complying. For official business, use only your TDLR email account, or if you are using a personal email account, please send those emails to a TDLR email account. When you do that, you are sending them to a TDLR server and you're complying with the statute. Also, send any texts containing TDLR-related business to a TDLR cell phone or a TDLR email account. The reason why I mention this is because there's a convenience factor in sending a text versus pulling up your email. But it is possible, if you want to just go ahead and send a text, to send it to an email address. You just type it in where you would type in the phone number, type in an email address, and that person will get that communication. Also, if you do happen to have any official information on your cell phone, private device, personal account, just forward that to a TDLR email account as soon as you can. So here's an example. Let's say you're attending a professional conference and during a break, you meet somebody new and mention your work on the commission. Later, that person emails you at your personal email address with a complaint about a program that TDLR regulates. Forward that email to TDLR staff or to yourself at your own TDLR email. And when you do that, you're putting that on the TDLR server and you're complying with the new statute. Also a tip, you can use Office 365, which is a website. It's essentially accessing Outlook on a website to check your TDLR email account. Or of course you can use your iPads. There are some more legislative updates. I'll skip the first one since you can just read that one. But the second one has to do with the situation where we do get a request for information that you have. In that situation, staff will contact you and ask you to forward that information to them. The law now says that you have to turn that information over to the department within 10 days. So, of course, we'll probably ask you for it sooner than the 10 days so that we can meet our statutory deadlines, but that's a new development in the law. And if you don't turn over the information, the agency could be sued for withholding private information, or public information, excuse me, and that includes, of course, costs of litigation and attorney's fees. So the last slide is resources for you. The first bullet point is that online open records training that Mia was talking about. It's mandatory. You're only required to do it once. So if you've done it once, you've fulfilled your responsibility under the statute, but it's always a good idea to go ahead and do a refresher every so often. If you haven't done it yet or you want to do a refresher, when you get to the very end, you're going to get a certificate of completion. Please forward that to us, or you can forward it to Tamla, because we're required by law to maintain that in the department's files. You can see the rest of these, and they're provided to you in your written materials. We have our phone number and email address. You can contact us whenever you'd like. And we're available for any questions you might have. I think it's in your written materials, but I'll make sure after the meeting that you get it. Okay, thank you.
Any other questions? Just real quick, if we get emailed personal in our TDLR email, right, do we retain it once, or we forward it to a TDLR employee? Are we required to retain it after that, or we're done?
No. Once it's forwarded to a TDLR employee, then you're fine.
Any other questions?
Yeah, I had, like, for example, if I chair multiple different things and I have one email box that goes in there, as long as it maintains through my TDLR, am I protected that way?
Yes, as long as it goes to the TDLR email account, then you're fine.
Okay, thanks.
All right, thank you.
Thank you, ladies. Thank you so much. Okay, we're going to move on to item I, contested cases. If you're here today for a case and you wish to speak to the commission, we'll call you up. We announce your case. You will hear from your prosecutor first, and we'll have an opportunity to speak. Make sure you fill out a public comment form. If you're going to come up, I need a public comment, and you can forward it to Tamla. Make sure you speak in the microphone, say your name and who you represent. I'm going to state this clearly. The commission can only consider information that is in the record from when the case was heard at SOA. You must limit your comments to those matters that were present in the SOA hearing, okay? And so I think Vicki Nguyen is going to be for Ken Sharp. Where's?
Mr. Sharp's sick today. I'll be
Oh,
presenting
okay,
for him.
okay. Want to make sure I wasn't seeing something. Have y'all filled out?
Yes, Your Honor. Yes, Your Honor.
Okay, perfect, okay. So, Mr. Thielen?
Good morning, Commissioners. My name is Trevor Thielen. I'm a prosecutor with the Enforcement Division. I'm presenting today on behalf of Ken Sharp, who handled the case, this case in every other respect, but he couldn't be here today. We recommend that you accept the Administrative Law Judge's recommendation and revoke Vicki Nguyen's massage therapist license because the law requires you to do so. In 2007, the Department of State Health Services, or DSHS, gave Ms. Nguyen that license. In 2008, she pled guilty to and was placed on deferred adjudication for prostitution. She served a year of community supervision. From that point until 2017, when the massage program was transferred to TDLR, DSHS renewed Ms. Nguyen's license. Though it should not affect the outcome of the case, we don't know if DSHS was aware of her prostitution case during those renewals. In 2018, she applied to renew with TDLR after the program had been transferred to us. Since she reported no recent criminal history, we renewed her license automatically, but we followed up with our standard criminal background investigation. It was at this point that we first learned of the prostitution plea and the deferred adjudication. The plea and the court ruling require you to revoke her license under two different statutes, neither of which is in Chapter 53 of the Occupations Code, the law that you normally use in criminal history cases. These Chapter 455 statutes affect only massage therapy licenses, and you can find them on the handouts you've been given. The first statute states that a person is not eligible for a massage therapist license because of a guilty plea to or deferred adjudication for a prostitution offense. Either circumstance can make a person ineligible, and they both make Ms. Nguyen ineligible and therefore require revocation of her license. The second statute states that TDLR must revoke the license of a massage therapist who has pled guilty to or been placed on deferred adjudication for prostitution. These statutes are clear. Ms. Nguyen hasn't been eligible for a massage therapist license since 2008, and even though she has held one, you are required to revoke it. This case is different from most others you've considered before because it involves a legal procedure called summary disposition. When there are no fact issues for the ALJ to decide, the ALJ can decide the case based only on the law that applies to those undisputed facts without holding a hearing. In this case, TDLR filed a motion for summary disposition because Ms. Nguyen's plea of guilty to and deferred adjudication for prostitution were not subject to dispute. The ALJ agreed and concluded that those statutes I referred to on the handout require revocation of her license. The ALJ granted TDLR's motion, canceled the hearing, and issued a proposal for decision that recommended you revoke Ms. Nguyen's license as required by law. We ask you to adopt the PFD as written, which would be in line with your previous decisions in the Hui Zulu case and the Lisette Martinez case, both of which involved massage therapists who had been placed on deferred adjudication for prostitution. The law required you to revoke both of those licenses, which were erroneously issued by DSHS. The law requires you to do the same thing here. I'd be happy to answer any questions that you have.
Thank you, Mr. Steele. Any questions for Mr. Steele? Okay, Mr. Levins?
My name is Jim Levins.
Jim
I
Levins.
proudly represent Miss Vicki Nguyen. It's a privilege
Just
to
to give
be.
you, I want you to we gotta contain it to the SOA, okay? I'm not sure if you can make sure that we have that evidence only, okay?
Yes, may I proceed?
Yes, sir.
This is my first time before this distinguished board, and I appreciate the privilege of being here. I'd also like to thank opposing counsel for his cordiality and professional courtesy to me this morning. All right. I respectfully and strongly disagree with opposing counsel's position on this matter. Section 53.021 of the Texas Occupational Code provides a clear exception to this matter. I will quote 553.021 C1. A licensing authority may not consider a person to have been convicted of an offense for the purposes of this section, regardless of the statutory authorization, if the person entered a plea of guilty or nolo contendere. Your Honors, we are speaking about a hero family. This family, Miss Gwen's family, was subjected to 10 years of imprisonment by the North Vietnamese communists after his distinguished service for our country in the South Vietnamese War. Her mother, Miss Gwen's mother, was in prison for 10 days, and the only reason she was released was because of the 5 children. Miss Gwen was so afraid of the entrapment that she underwent by the
Commissioners,
vice.
I have to object. There was no hearing in this case because it was a motion for summary disposition case. There was no evidence provided by Ms. DeWin in the case. The only evidence on the record is what we provided to support the motion for summary disposition, and none of what counsel is outlining here is within that.
Counsel, I know, I got you. I just got to, we're just going to, but the summary decision, we have to focus on that. If you can counter that, why, on a legal statute or regulatory statute, we can address that. I can't hear.
I am, Your Honor, once
I
again.
apologize.
I understand, and I respect opposing counsel's diligence in prosecuting this matter in the way he sees fit. Once again, this is an exceptional case. This family are heroes, and the reason she pled guilty was because of her fear of going to prison.
Mr. Chairman, this is Brad Bowman. Just to maybe kind of further what your explanation, Mr. Chairman, we are prohibited at this stage of the proceeding from taking additional evidence, so this is not an evidentiary hearing. So if it wasn't presented before SOA, then the commission can't consider new information or new evidence to make its decision. So I think what we're trying to do here is to confine the discussion to only those issues that were to.
It's kind of hard to hear you. Go ahead, Brett.
Which we have to confine the discussion here today to only those issues that were before SOA, and if they're understand if this wasn't testimony at the hearing, we can't consider it or take it into evidence today. It's just not that kind of proceeding. So I just wanted to try to clarify that a little bit.
If you want to counter the summary judgment specifically, we can talk about that, or you can address that. But we cannot hear evidence too much. Mr. Bowman said it's just something we can't do. I understand what your petition is. Now, I'm going to say this at the very end. This isn't your last stop. You'll have some others, but I need you to make sure that you contain those arguments to that summary decision.
I appreciate it, Commissioner, and once again, this is my first time at a proceeding like this, and I'm doing this for the family. So once again, Ms. Gwen at this point relies on Section 53.021 C1 as her counter to opposing counsel's position. And we respectfully request that Ms. Gwen's license not be revoked and that she be able to continue to support her family. I have no further response.
Thank you, Counselor. Hey, we can give you a lot of latitude on this, but I appreciate you.
Thank you very much.
As far as subsection C of 53021, I need to back us up a little bit. I said in my presentation this case wasn't based off of Chapter 53, the usual one in which we bring cases like this. 53021A is a general power afforded not only to this commission but to other departments, other agencies to revoke license. It's a discretionary power, and it's based only on convictions, except in some circumstances. Those circumstances are explained about where you can use deferred adjudications in subsections C, D, and E of 53021. If you read the complete subsection C, it says, except as provided by subsections D and E, notwithstanding any other law, a licensing authority may not consider a person to have been convicted of an offense for the purposes of this section. So you've got two things in there. First off, subsection C clearly says we're only talking about 53021. That's all we're talking about. And the second thing that it says in the same sentence is look to D and E. There are some circumstances under which you use deferreds. neither of those situations applies here. That's a dance that we go through when we're looking at the general. But in this case, we're looking at specific statutes regarding massage therapy. They're different. In general, mixing my words here, the specific controls the general in the law. If we have two laws that seem to be talking about the same thing, the more specific one is the one that we're supposed to go with. In this case, the Chapter 455 statutes not only talk about convictions, not only talk about deferred adjudications, they talk about simply a plea of guilty or nolo contendere is enough to make a person ineligible for a massage therapy license. She pled guilty, she was placed on deferred adjudication, and the judge recognized that there's no more factual analysis that's needed to come to a decision in this case. We never pled Chapter 53, the section that counsel is referring to. It's simply irrelevant to this case. And this argument was advanced in the Huizulu case you heard a few months ago. The judge asked us to brief him on, should subsection C limit me from being able to apply these massage therapy statutes? And we argued the same argument that I'm giving you here today, and the judge agreed, and in his PFD ruled, no, those 455 statutes, they control in that situation where there was a deferred adjudication for prostitution, recommended that you revoke. Our recommendation is the same here today. And I'll also just add, I have sympathy, not only for Ms. Nguyen, but for other folks who are affected by this law. It is fairly draconian, but it is extraordinarily clear. And the concern, I believe, is that prostitution is a special concern in the massage therapy industry. It has great effects, and one of our tools, one of our best tools at eradicating the problem of prostitution and sex slavery and human trafficking in the massage therapy occupation is these statutes that make folks that either voluntarily or involuntarily engaged in prostitution, it takes them out of the industry and makes them not as useful to the traffickers, to the pimps, to the people who would take advantage of that situation. So we're asking you to focus on the same law that the judge said applies. They don't deny that the deferred adjudication happened. There's no factual issues here. He talks about entrapment. There's nothing in the documents that talks about an appeal, successful or not, from the deferred adjudication of the prostitution case. And those are the facts and the evidence that are before you, and we ask you to please decide the case based off of that as the judge urged you to.
Thank you, Mr. Dean.
May I respond?
Sure.
With respect to the wide latitude of opposing counsel's rebuttal, the reason there was no appeal was because Miss Nguyen was so afraid to go to jail because her father went to prison for 10 years and underwent torture under the communists. Her mother went to jail for 10 days. Your Honor, please, that was the reason there was no appeal. She was entrapped. There was, Miss Nguyen, were you guilty?
Again, I'm going to object to additional evidence.
I can't go to.
I'm doing the best I can. I'm doing the best I can fighting for
This
this.
isn't your last, I empathize with what you're saying, but I can't allow you to
Okay.
get to that place,
All right.
okay?
Then
There was no appeal, there's no appeal. Yes, sir. Yes, sir.
I was just gonna say, based on our commission and looking at section 455.12 and 455.251, if you read this through, a person is not eligible for a license of massage establishment, no matter if they've entered a plea of nolo contendere, guilty, or deferred adjudication. So those two things that are out there for me. And the other big thing is that we've already made two TDLR versus Martinez and TDLR versus Liu, so I'm recommending adopt PFD as written.
You're making a motion?
Yes.
Okay.
I'll second.
Any discussion? All those in favor, say aye.
Aye.
Opposed? Mr. Nguyen, my advice to you is this. I think the law should be adjusted. Our hands are what they are, okay? And we understand the challenges that families had. I think this is something the legislature should hear about. I recommend you talk to them and advise them on this issue, and I think you might see some openness in there. But I think the law is the law.
Thank you, Your Honor. Thank you.
right, next case, Ms. Shirk. And lighting, towing, and recovery.
Oh, I'm sorry, my leg is bad.
You okay, Ms. Shirk?
Yeah, I had surgery a few weeks ago, and at my age, you don't recover so fast. Commissioners, good morning. I'm Michael Shirk with the prosecution on this case. I don't know if it's been brought to your attention, but there has been a motion to continue this proceeding, and I would like to address that first, and I guess I need to ask General Counsel, do we need a ruling on that first?
This is Brad, but yes, I think that's would be appropriate for the commission to take up that issue first and take a vote, make a decision on the
Okay,
council's
why don't you
motion for
speak to that
continuance.
against the motion for continuance, I'm assuming, right, Ms. Shirk?
Yes, sir. On Sunday night, this past Sunday night at approximately 10:30 p.m., opposing counsel set out a motion for continuance seeking to postpone the hearing on this contested case hearing in your review of the proposal for decision. Of course, Monday was a holiday. Your staff works very hard, and some of us were here on Monday, so I filed my motion, or my response in opposition to the continuance. It's unjustified, first because it's untimely. To have waited 24 hours before today's hearing to ask for continuance is asking for you to exercise extraordinary discretion. There's a lot of work that goes into the preparation for these hearings, and the efficient administration of justice cannot rest upon somebody at the last minute asking without cause for a postponement in the hearing. In addition, it's not supported. The merits of the motion, there were two counsel representing respondent at the trial. Neither one, the second attorney, Ms. Trina Moulton, has not filed anything saying that she was unavailable to be here. Mr. Bruce, the other attorney, has not indicated that he was not fully aware of when this hearing was going to be, received due and adequate notice of it to otherwise justify his 24-hour request for a continuance. And in this case, I will also tell you that this is not merely a continuation of a hearing on a proposal for decision about whether or not administrative penalties should be imposed. Basically, this is a request to keep and I will say this very honestly, a very dangerous business in operation for another 4 months or until such time as we reconvene. There's no reason that this favor should be given to this business in light of their past history and in light of their present history. I do have with me this morning Senior Investigator David Cottonrother, who has investigated these cases. He testified at the hearing and is available as a resource witness to talk about this particular company and why this continuance should not be granted to allow them to remain in business, assuming you were going to vote on the proposal for decision today. Therefore, we ask that this motion be denied.
Is there anybody from Lighting, Towing, and Recovery? Okay, all right. Any questions for Mr. Shirk?
One question I had was on this, the one attorney had a court date today. That didn't happen on Sunday night, I'm guessing. I mean, our court, I'm not an attorney, so I don't know how court dockets are set, how far ahead they're set. But
No,
there's no date here on when this was set, so is that normal?
I can't speak to his docket. I would suggest that him not having said that it was set at the last moment to otherwise justify a 24-hour request speaks very loudly.
Okay, thank you.
Mr. Chairman, this is Brad Bowman. The document that we had for the trial setting that council provided was the judge signed on December 11th of 2019.
Okay,
So
I didn't see it. I couldn't find a date on it.
That's all the information that we have in terms of when that would have been,
Okay.
when that would have occurred.
Any other comments?
Yeah, I have a comment. Mr. Shirk, with the new, let's see, let me see the date on this. It was submitted, the SOA docket number 452-19-735, where you have the new 9 through 18. I would like to talk to Brad, our senior counsel, to ask about refunds and how we can change our, what we suggest should be if we decide to move forward.
Yes, sir, absolutely, and that would be, if the commission were to deny the continuance request and
Right.
move forward with the PFD, I think we would get into those issues, and the prosecutor would probably want to lay those issues out for you in that.
Can I make a motion?
Yeah, just give me a second
Yes,
to make
sir.
sure everybody else, because this, I want you to understand I understand the urgency, but justice alluded move quickly, so just be aware of what we're talking about here. Just the specific continuance of what we're trying, of the case, because the lawyer is on a docket, and there's evidence for that, so I just want to make sure everybody's aware of what we're looking about. Any other comments before Commissioner Callis? Commissioner? Okay.
I move to not extend contingency. The reason why is because, as Brad stated, that we've known about this case since December 11th. So I don't think we need to delay this hearing any longer.
Is there a second?
Second.
Any discussion? There is nobody here representing.
Correct.
I can tell you, just want to make sure everybody's aware of that. Okay. Okay. All those in favor say aye.
Aye.
Opposed? Nay. Do a roll call, please, Kim.
Dr. Callis?
Aye.
Commissioner Castaneda?
Aye.
Commissioner Garza?
Aye.
Dr. Wesson?
Aye.
Chairman?
Nay. All right, motion carries. Sir?
Commissioners, again, I wanted to introduce Senior Investigator David Cotton-Ruther, who's been our primary investigator on the flipping cases out of Harris County. He's available to answer questions afterwards, on the record, of course, about the scope, depth, and significance of the wrongdoing involved in these cases. First off, on your agenda, the way this case is docketed, there's a case ending in 8022 on your agenda. On the footnote 1 in the proposal for decision, it was noted that that case was non-suited, so that really is not in front of you. This case comes before you from a proposal for decision that was issued on November 8, 2019. This proposal for decision was subsequently modified by the administrative law judge's exception letter issued on January 8, 2020. Just procedurally, after a contested case hearing at the State Office for Administrative Hearings, an administrative law judge will issue a proposal for decision, or PFD. The parties are then given an opportunity to ask the judge to make changes because they feel that the judge got issues of law wrong or questions of fact wrong. Those are called exceptions. The parties file those exceptions if they wish to, and then the judge will issue an exceptions letter, either accepting or denying the requested changes. I did file an exception, many exceptions to the judge's proposal for decision. Opposing counsel did not file any exceptions. In this case, the administrative law judge did make changes to her proposal for decision in response to the exceptions I filed. I'll just address the proposal for decision right now. The administrative law judge recommends that respondent's towing company license be revoked and that a $20,000 administrative penalty be assessed for respondent's knowingly, fraudulent, deceptive, and dishonest conduct in the performance of 4 separate tows. This, of course, is consistent with earlier commission orders imposing a $5,000 penalty for each flipping case that has come before you. These penalties are warranted. The ALJ specifically found that respondents' repeated violations of the law were, quote, serious and especially egregious, and, quote, harm the public. The proposal for decision found that respondent Gareth Francis engaged in 4 separate instances of flipping. That is to say, his towing company systematically and purposefully utilized a business model targeting and victimizing vehicle owners who had just been in accidents. While the vehicle owners were still at the accident scenes, respondent fraudulently induced them to sign authorizations permitting the totaled vehicles to be taken to and have work done upon them at unlicensed or unregulated body shops instead of being taken to vehicle storage facilities. Interestingly enough, 3 of the body shops, or in 3 of the instances, the cars were taken by respondent's tow company to respondent's body shop. As a result of this, the administrative law judge found that Mr. Francis, respondent in this case, reaped an ill-gotten financial windfall. The administrative law judge made the specific factual finding that, quote, the evidence demonstrates that Mr. Francis or tow drivers operating under his authority used deception and misrepresentation to induce the vehicle owners to authorize the tow and repair of their vehicles at an unregulated body shop. The administrative law judge continued and noted, quote, respondents were engaged in a calculated flipping scheme in each of the 4 instances. The administrative law judge, in her proposal for decision, was very straightforward as she reached her conclusion. She noted at page 17 of the PFD that Mr. Francis had a clearly demonstrated practice of controlling, operating, and directing the operation of tow trucks in the state of Texas in a manner that incorporated as a business model fraud and deceit. The administrative law judge did not accept and in fact rebutted respondent's argument that the company could not be held responsible for the wrongdoing of its drivers, the flipping incidences. The ALJ correctly noted that a towing company, quote, may not delegate or overcome the duty to operate with honesty, integrity, and trustworthiness. In an earlier decision from the commissioners, TDLR versus Rodolfo Meraz, you issued an order on November the 5th, 2019, assessing a $5,000 administrative penalty and revoking the towing company license, again, of a sole proprietorship for the conduct of a driver based on, among other things, the definition of a towing company as found in the Occupations Code. A towing company is defined as an individual, association, corporation, or other legal entity that controls, operates, or directs the operation of one or more tow trucks. Clearly, by that definition alone, there is perceived to be control. A tow truck company cannot just rent out trucks to any driver and abrogate its responsibility to operate with honesty, integrity, and trustworthiness. This case before you today is similar to Mr. Meraz, the Meraz case, as it also involves drivers who are operating respondents' tow trucks, issuing tow tickets under respondents' license, carried work orders for respondents' body shop in respondents' trucks, misrepresented the nature of the forms to the vehicle owners, and operated a body shop at the same location as the towing company. In addition to not accepting the respondent's argument that the tow company could not be held responsible for the conduct of its drivers, the administrative law judge was aware of well-established precedent from the Texas Supreme Court, holding that when a duty is imposed by law to protect the public's well-being and safety, the party bearing that duty cannot escape it by delegating it to a third party. And it was an interesting case. It was an M-Bank decision out of the Texas Supreme Court in 1992. In that case, a secured creditor, a bank, hired a towing company to repossess a vehicle. In a repossession case, the tow company or anybody who's doing the repossession cannot breach the peace, cause trouble. There was a breach of the peace, and the vehicle owner or the person who was making payments on the vehicle sued the bank directly. The bank said, we can't be held responsible for an independent contractor's breach of the peace. And the Supreme Court expressly rejected that argument on the same basis as the administrative law judge held today. That is, that when a duty is created to protect the public, that cannot be abrogated, sidestepped, or ignored by delegation of that duty to a third party. In this case, that's exactly what the administrative law judge held. It's also interesting to note that the legal duty to take a vehicle from an accident scene to a vehicle storage facility rests exclusively on the towing company. It's not one of those duties that is shared between a towing company and a body shop. The administrative law judge is holding that, quote, a towing company may not delegate or overcome the duty to operate with honesty, integrity, and trustworthiness, then, of course, precisely implements and reflects the well-established law that the Supreme Court issued in the M-Bank case. Therefore, staff agrees with the administrative law judge that Mr. Francis's towing company engaged in such systematic fraud through the use of flipping techniques as to warrant a $20,000 administrative penalty. Again, that administrative penalty is fully consistent with earlier decisions that you've had with $5,000 per flip. We also believe, and we also support the administrative law judge's recommendation that the license be revoked for his conduct. However, I believe the administrative law judge erred as a matter of law in failing to recommend consumer refunds and for failing to assess penalties for legal violations, which she found, as a matter of fact, had occurred. She noted in footnote 44 of her proposal for decision that a $20,000 administrative penalty and license revocation was adequate to deter future violations. The department strongly disagrees with that and believes that the legitimate and important goals of general deterrence, that is sending a message to those tow truck operators and companies that do involve themselves with flipping, needs to be sent a much stronger message. The general deterrence is not served by waiving and overlooking and not imposing administrative penalties where they were proven to have occurred. The testimony of the witnesses, which was recited in the administrative law judge's proposal for decision, should leave no doubt that the problem of flipping is getting worse, not better. The ALJ summarized the testimony of various law enforcement officers as establishing the reality that, quote, flipping is an increasingly common problem in Harris County. Investigator Cotton Ruther testified that between 40 and 50% of the towing and storage facility cases that he receives involve flipping. Harris County Deputy Sheriff Simon testified that she must contend with 50 flips a year, that the problem is, quote, rampant, and of such severity that the Sheriff's Office in Harris County has actually had to make changes in its SOPs for the officers dealing with these cases. In fact, you noted in the Mraz case that incidents of flipping in the greater Harris County are a substantial problem. Because of this, we believe that a much stronger deterrent must be issued in this case, that is to say that administrative penalties should be issued for all the violations that took place. The administrative law judge made a factual finding that respondent charged tow fees, which exceeded the maximum rate in Harris County of $145.50 for incident management tows. In case identified as TOW 2017-0021-041, the administrative law judge found in her finding of fact number 20, as modified by the exceptions letter, that the vehicle owner was overcharged by $471.25. We believe that refund should be ordered. In case number TOW 2018-00-16579, finding of fact, the judge found that the vehicle owner was overcharged by $654.50. The administrative law judge did not recommend that the victims get refunded the overcharges. She also did not recommend that administrative penalties be assessed for these purposeful and gross overcharges to the citizens. Because these overcharges were second-class D violations under the enforcement plan that was in effect at the time of the violations, staff sought, in conjunction with the refund, an administrative penalty of $1,800 for each instance of overcharging, which would be $3,600 for the two of them combined. Therefore, staff requests that the proposal for decision not be adopted as written and is supplemented by the exceptions letter, but that respondent be assessed an additional administrative penalty of $3,600 for the overcharges and ordered to refund the overcharges to the citizens. In my exceptions, I also noted that the administrative law judge found, in finding of fact number 12, that the vehicle owner in TDLR case number, and all of this is in the written materials that I have given sort of as a roadmap, finding of fact 12, that the vehicle owner in TDLR case number 2018-00-16579 was not provided with a copy of the tow ticket as required by law. Again, the administrative law judge did not recommend assessment of an administrative penalty for this second-class C violation. Staff sought a $1,500 administrative penalty. There's simply no justification for allowing respondent to retain these ill-gotten benefits rather than to refund the money to the victims. There is likewise absolutely no justification to excuse him from the legal consequences of his behavior by waiving penalties which should be imposed for proven violations of the law. Unless and until those towing companies which engage in flipping recognize that the Commission has no tolerance for consumer fraud and dishonest business practices by its licensees, flipping will continue. It is just simply too lucrative, especially if, as here, excess fees are permitted to be retained and penalties are just waived. Staff requests, therefore, that the Commission issue its order assessing an administrative penalty of $25,100, ordering refunds to the vehicle owners for overcharging in towing fees, and revoking respondent's towing company license number 0064890448. Both myself and Investigator Cotton Ruther are here to answer any questions.
So let me get this straight. So you want additional 5,100, correct?
Yes.
3,600 on the overcharge, and then on fact finding number 20, the difference of 471.25
For the refund.
the refund.
That's correct.
Okay.
So it'd be two refunds.
Give me
and-
the math on the 5,100, please.
Sure. Have you received the staff's proposed changes to the administrative law judge's proposal for decision?
Yeah, I did.
Okay.
I got 36 on the overcharge, right?
Yes. Okay. What I'll do is I'll go down each one of the TDLR cases. In TDLR case ending in 21041,
Yeah.
that was an overcharge. We're asking for a refund of $471.25.
Got it.
We're asking for an administrative penalty in that of $1,800.
Okay.
In TDLR case ending in 16579, we're asking for a refund of $654.50 and another administrative penalty of $1,800.
Okay.
In TDLR case ending in 16579, where no tow ticket was issued, we're asking for an administrative penalty of $1,500. As I do the math then, that's $5,100, changing the administrative penalty from $20,000 to $25,000.
$25,100.
Yes.
Got it. Okay. Any questions, Mr. Shirk?
Mr. Chairman, this is Brad Bowman. I just wanted to kind of get on the record that this would involve some changes to conclusions of law if you go this direction.
And can you go ahead and give us those conclusions, make sure you guys know which number of the conclusion law?
Commissioners Della Lindquist, Deputy General Counsel. If you can see on page 2 of the document that Mr. Shirk provided to you, where it says new 9, new 10, and new 11, those would be additional conclusions of law that you would want to add, because the findings of fact do support it. Findings of fact number
20, 14,
14 and 20.
and 12.
And 12. So if you wanted to make the changes they recommended, it's supported by the facts. You wouldn't be needing to alter any facts, which you can't do. But you could add these two, and you're welcome to read them into the record. But where it says new 9, new 10, and new 11, and then you would come out with a new.
I'm sorry. Last sentence was what?
11.
So new 9, new 10, or new 11.
Yes, sir.
And 12, 16,
and 12.
17.
If you wanted to add the tow ticket.
Do you want us,
as well.
if they want to make that motion, you want us to read this whole thing, or can we just submit this to the record?
Would you like? Prefer to read it.
Okay, so
No,
motion.
no. So it would be, you would read 9, you would read 10, you would read new 11, new 12, not 16 or 17, because that's already really proven in the facts. And then you would read new 18.
Okay.
Take a deep breath.
Yeah, somebody's ready, prepared to make.
So,
it.
Mr. Chairman, first thing I would like to make a motion to do is not adopt the original PFD.
To modify it?
And I will modify by, starting with new 9, Respondent Francis violated Texas Occupation Code 2308.2065 by charging incident management tow fees in cases TOW 201-700-21041 and TOW 201-800-16579, which exceeded those authorized by a political subdivision in the instance, quote-unquote, Harris County. New 10, the commission may order refunds of overcharges. ID respondents must immediately make a refund to the vehicle owner in TDLR case TOW 201-700-21041 in the amount of $471.25 and must immediately make a refund to the vehicle owner in TDLR case number TOW 201-800-16579 in the amount of $654.50. New 11, under the department's enforcement plan in effect at the time of the violations, overcharging a vehicle owner in an incident management tow was a Class D violation. Because each instance of respondents overcharging vehicle owners was a second violation, an administrative penalty of $1,800 is warranted in each instance for a combined administrative penalty of $3,600 for respondents overcharging in the vehicle's owners. With all that being said, with that new information, a total of $25,100 administrative penalty plus revocation of license. That's my motion.
Did you go through all the news?
We would need 12, new 12.
12 and 18.
If you wanted to add the tow ticket violation as well, which you
Yeah,
don't have to, but.
Okay.
12 and 18.
New 12, failing to provide a vehicle owner with a copy of a tow ticket at the scene of a tow when the vehicle owner is present is a violation of 16 Texas Administrative Code 86.709B and was a Class C violation of the department's enforcement plan at the time of the violation. Respondent should be assessed an administrative penalty of $1,500 for failure to issue a tow ticket in TDLR case TOW 201-800-16579. And the final one, based new 18. Based on the above findings of fact and conclusion of law, respondents should be ordered to refund the vehicle owners the amount of which they paid in tow fees exceeding the maximum amount permitted by Harris County Tow Ordinance in TDR case number TOW 201-700-21041. This sum is $471.25, and in TDR case number TOW 201-800-16579, the sum of $654.50. Based on the above findings, the total administrative penalty would be $25,100. Mr. Chairman.
Thank you. Thank you. Is there a second?
Second.
Any discussion? Okay. All those in favor say aye.
Aye.
Opposed? Good job, Mr. Sherman.
Thank you, Commissioners.
Thank you, Commissioner.
You're welcome, sir.
All right, Mr. Thielen, where you at? Okay, you're back at us. Zach Van Lee? Or Lay?
Commissioners, I don't think Mr. Lee is here, but I wanted to let you know, he had a Vietnamese translator at SOA. I think we provided one, and I just wanted to make sure he's not here in the room, both in English and Vietnamese, before we proceed, just in case he's here.
And we do have a translator available.
Do you see him in the room?
That's our translator.
Oh, it's no, not the translator, Mr. I'm sorry. Should have been more specific. You don't see him in the room, right?
I don't see him in the room, but it's been a little over 2 months, and I've had some
Okay.
hearings since then.
Okay.
Zach Van Lee? Zach Van Lee?
All right, Mr. Thielen.
Good morning, Commissioners. Again, I'm Trevor Thielen. I'm a prosecutor with the Enforcement Division. I handled this case at SOA. We recommend you accept the majority of the Administrative Law Judge's PFD, which ultimately recommends that you revoke Zach Van Lee's cosmetology operator license. However, the PFD also recommends that you interpret part of the Occupations Code far differently than you have consistently interpreted it for the last 10 years. We do not agree with this portion of the PFD and will outline why you should amend it after we go over why the ALJ ultimately agreed that Mr. Lee's criminal history requires his license be revoked. Mr. Lee was granted his cosmetology license in 2013. In March 2018, at age 46, he and his wife were in the middle of a long-standing argument about money. One day he entered the salon where she worked, threw $500 in cash at her, and then pointed a gun at her in front of other witnesses and a security camera that recorded the incident. He then left the salon without firing the weapon, but he did succeed in terrifying his wife, who was crying while she told the police that she feared for her safety. Mr. Lee testified at the hearing that the gun was only a BB gun, but there's no indication in the police report that the victim or the witnesses were aware of that at the time. Further, in May 2018, Mr. Lee pled guilty to the charge of aggravated assault by using a deadly weapon capable of causing death or serious bodily injury. The court placed the respondent on deferred adjudication probation for 3 years. His probation officer reported that respondent was complying with his probation other than owing $115. That probation is scheduled to continue until May 2021. The respondent did not present any letters of recommendation or proof of rehabilitation. The ALJ determined that Mr. Lee's assault was directly related, not only because it appears on your criminal conviction guidelines, but particularly directly related in this case because he committed the crime in a cosmetology salon and the victim was a fellow cosmetologist. The court determined that the offense was so serious that the preponderance of the evidence justifies revoking his license and denying his renewal. And we recommend you do just that, for those reasons outlined by the ALJ. However, in the second to last paragraph of the PFD, the ALJ made additional comments about the law that we encourage you to explicitly and clearly reject. In essence, the ALJ has recommended that you nullify a statutory power that SOA and many versions of this commission have recognized and used since the legislature granted you this power in 2010. Before I get into the specifics of the statute, I want to remind you that you wield the power to interpret the law in your cases. SOA takes the first pass at that in their PFD, but the legislature has said and the Texas Supreme Court has confirmed that you get to change any conclusions of law from the ALJ if you believe the ALJ hasn't properly applied or interpreted the law or your prior administrative decisions. The legislature has also said that SOA ALJs should consider TDLR's policies when conducting a hearing. Our hope is that a clear decision in this case will be considered by ALJs in other cases when confronting the same legal question, which will undoubtedly come up in almost every criminal history case and could come up in other cases as well. The question is this: do you, the Commission, have the power to deny or revoke a license or deny a license renewal based only on evidence that the person lacks the honesty, trustworthiness, and integrity to hold that particular license? You answered yes to that question a few months ago in the Wee Tang case, though that case focused mainly on questions about how to apply the massage statutes to his disorderly conduct offense. After that, you declined to address the issue in the Bleem case, where I missed the footnote where an ALJ briefly outlined her no answer to this question until it was too late for me to file robust exceptions that would force the ALJ to address the flaws in that legal interpretation. In this case, despite there being no complaint or legal argument from Mr. Lee about 514012, the ALJ again answered no to that question. This time, we filed those exceptions, and the ALJ filed an exceptions letter explaining that she was rejecting them. Today, you will consider the same arguments and decide where you come down on them. This is the statute that the Commission has used for the last 10 years as the basis for that power. As you can see, subsection A says very plainly, notwithstanding any other law, the Commission may determine that a person is not eligible for a license based on that person's criminal history or other information that indicates the person lacks the honesty, trustworthiness, and integrity to hold a license issued by the Department. In my exceptions, I showed how SOA and the Commission first used this power in 2010, the year it first became effective, as one reason to deny and revoke licenses, along with other powers granted to you in Chapters 51 and 53 of the Occupations Code. I also provided the judge a breakdown of 21 cases between 2019 and 2015 where 19 different SOA ALJs used this same statute in the same way, each time with the ultimate decision of the Commission supporting that legal interpretation. I also pointed out that ALJ Starnes, the judge in Mr. Lee's case, issued one of those PFDs just last June when she used 514012A to deny a license application. In response to my exceptions, the ALJ admitted that all of this was true, but did not change her legal conclusion. She pointed to a different section of 4012 to explain her change of heart on this statute. Subsection G states, a determination under this section is not a contested case under Chapter 2001 Government Code. Chapter 2001 of the Government Code is the chapter which governs the SOA hearing process that proceeds your decisions about cases here at the Commission meetings. ALJ Starnes concluded that subsection G means that when you make a determination under subsection A, that case can't go through SOA, and therefore can't be the basis for actually denying or revoking a license. We believe the ALJ's analysis is flawed for a few reasons. First, subsection A, and only subsection A, starts off with the words notwithstanding any other law. That language cuts subsection A off from the subsection G restriction below, leaving it free of the not a contested case language, which nevertheless does apply to the rest of the statute. If we stick to the notwithstanding any other law instruction from the legislature, we find that 4012 actually acts like two different statutes that are grouped together under the same heading and code number. Unlike subsection A, which focuses on a commission determination, subsections B through G focus instead on a department determination of a very different sort. The difference between that department determination and your commission determinations is the key to understanding why one should be a contested case and the other one shouldn't. B through G govern how we, the enforcement staff at the department, are supposed to create and issue criminal history evaluation letters when requested. If you're not familiar with them, these evaluation letters, or determination letters as they're described in the statute, allow citizens to pay a small fee to get a quick, less formal answer about whether their criminal history could affect them from getting a particular license. The letters are useful to them because potential applicants get reliable answers about their eligibility before they spend a lot of money and time on education, training, equipment, leases, insurance, etc. Section E in particular clarifies that if the department sends an evaluation letter determining a person's not eligible, we can't stop the person from applying. That's why it makes sense that a person can't take their determination letter to a contested SOA hearing, because they can still apply. And if formally denied, they can ask for a hearing then and get a commission decision at the end of that process, and we're all familiar with how that works. Separating 4012 into two distinct sets of rules about your licensing powers on the one hand, and the department's evaluation letter on the other hand, also makes sense when you examine subsection B closely. When we write an evaluation letter, the legislature requires enforcement staff to examine whether the person is eligible for a license under 3 different laws. The first, in yellow, is subsection A, your commission determination about honesty, trustworthiness, and integrity, and whether licensure is appropriate. The second, in blue, is 51.356 of the Occupations Code, which allows you to revoke licenses based on certain deferred adjudications. And the third, in green, is Chapter 53, which allows you to revoke based on offenses directly related to the occupation. ALJ Starnes agrees that you have the power to revoke based on 51.356 in blue and Chapter 53 in green. In fact, those are the exact statutes she recommends you revoke Mr. Lee's license under. But if she's right, and that subsection A power in yellow doesn't mean anything, it would lead to absurd results that we don't think the legislature intended. First, you'd never actually be able to make a determination about honesty, trustworthiness, and integrity in subsection A, because if a case can't go through a contested case at SOA, it can't ever get to you here at the commission meetings. Second, despite you never being able to use that subsection A power, subsection B here would still require enforcement staff to issue an evaluation letter determining what you would do with that power if you could actually use it. Both of those results are absurd, but they are what happens if we follow the ALJ's interpretation of the statute to its natural conclusions. Even if you think the ALJ's interpretation of the law is just as reasonable as the one that we've argued for, the Code Construction Act requires us to presume that the entire statute was intended to be effective, that a just and reasonable result was intended, and that a result feasible of execution was intended. You can avoid the absurd results inherent in the ALJ's recommendation by concluding that subsection G does not apply to subsection A. The ALJ also concluded that because subsection A only talks about whether a person is eligible for a license, it only applies to original applicants and not to current license holders like Mr. Lee. She pointed to one commission decision from 2014 as precedent for this decision. That case, the Calvin Walker case, dealt with a host of other issues as well. And it appears from my review of that case that the discussions and arguments did not focus on the 4012 issue nearly as closely as we have in this case. The Calvin Walker decision was approved by only 4 commissioners. None of those 4 commissioners are currently on the commission. Mr. Butler was on the commission at the time, but it doesn't appear that he was involved in the final decision in that case. The ALJ did not address the 12 more recent decisions I showed her where SOA and the commission have ruled that the commission can use 4012A in cases involving current licensees. The ALJ also did not address our argument that the statute says that the commission can decide that a person is not eligible and that license holders are naturally persons. If you can determine that any person's actions make them ineligible, then you must be able to determine a licensee's actions made them no longer eligible. And if you have that power to determine eligibility for current licensees, then you naturally have the power to revoke. A few months ago, in the Hui Zulu case, this commission made a similar interpretation of a massage statute. The massage statute used the words, "a person is not eligible for a license" in regard to prostitution and human trafficking offenses, and the respondent, a current licensee like Mr. Lee, argued that language must only apply to an original applicant. In that case, the SOA ALJ disagreed and found that a current licensee can become ineligible under the massage statute. The commission agreed with and adopted this interpretation. Those exact same words, a person is not eligible for a license, appear in 51-4012A. To be consistent, you should apply the same meaning in both statutes and find that you can use 51-4012A to revoke current licenses just as you have for a decade. Finally, the ALJ opined that there would be no harm in nullifying your 51-4012A power because she couldn't find any examples of the Commission utilizing that power by itself rather than alongside other license denial powers like 51-021A or the massage statute we just looked at. If the law permitted me to write exceptions to her exceptions letter, I would have pointed out that this Commission recently did just that. In your October meeting, you found that 51-021A and the massage statutes didn't apply to Wei Tang. But you further found that you had the power to sanction Wei Tang's license based solely on 51-4012A because her offense demonstrated she lacked the honesty, trustworthiness, and integrity required for the license. I respectfully request that you reject each rationale from the ALJ in this case for nullifying 412A. If you choose to do so, I expect you'll still see the issue come up in a few more cases. However, if we have a Commission decision that makes your position on the matter crystal clear, we may be able to present it as evidence in our hearings and help SOA ALJs understand that your current and fully informed views on how these statutes will be interpreted controls. On the other hand, if you agree with the ALJ's interpretation and want to invalidate the way 4012 has been used in the past, a crystal clear message to us that that's the case will direct us to implement that interpretation and change the way we examine the relevance of offenses and other types of evidence that sometimes is only relevant because it helps us find out whether a person is honest, trustworthy, or has integrity. I'd be happy to answer any questions you may have, and if you'd like to explore how to answer yes to the question on the screen, I can provide you with copies of proposed conclusions of law, which I believe would accomplish that end.
Okay. When you refer to us, you're speaking on behalf of enforcement, entire enforcement, correct?
Yes.
Okay. Okay. That's a lot. All right. So it's kind of a multi-layer in regards to the case that we're hearing, Mr. Lee, and then the specific application of the statute that he's applying to. So this would be a great time for questions, especially to pull aside counsel on this. Do you have any comments, Brad, on this?
This is Brad Bowman. Only if the commissioners have questions for me. And I'll leave it at that.
Okay. Commissioners?
Well, I mean, probably more for Brad or for you, Trevor. Whenever the legislature met and passed this Section A, they did that with intent to make sure that all occupation licenses, you look at the human as a person as honest, trustworthy. I don't think that that's the intent of what the legislature would want us to do away with. So I do agree with your statements, and I would like some clarification. So how do we move forward to still to maintain Section A to where we still like rescind the PFD, but still accomplish what we want to do for a revocation of licensure?
Well, I believe you could do that with proposed conclusions if
Can
you'd
I
like me to
see
pass
the-
them out.
Yeah. Brad?
I have, I think so. Trevor's going to thank you. Trevor's handing out some proposed changes to conclusions of law, and so that's an option for you. I think another option would be to include in the preamble to your order a statement about the Commission's position on the application of this particular section. And the reason I say that is because there are not any findings of fact and conclusions of law
Disputed.
that actually address this particular
Correct.
issue. And so I think what Trevor's proposing is to add some conclusions of law that do address it. You still have plenty of basis to revoke the license under Chapter 53 either way, so this doesn't change the outcome of the case. It just sort of bolsters the legal argument. And I think there's really two ways to go about it if you are persuaded by the prosecutor's legal arguments So I just wanted to kind of put that in front of you.
And in the Wee-Tang case, you did change the preamble. There were no changes to the conclusions of law in that case. I think here, you don't have to make any changes to the finding of fact, because our arguments about honesty, trustworthiness, and integrity, but emphasizing on the trustworthiness, are that his actions in that cosmetology salon demonstrated that he lacks the trustworthiness to hold the license. So we believe that you could add conclusions of law that don't change the result of the case. He's still revoked under the same arguments that the ALJ put forward, but also additionally say there's support for revoking his license because of 401(2)A.
So let me, for the commissioners, I want you guys, the preamble, your petition is that if we don't modify this on the enforcement's behalf, is that it would inhibit our ability to enforce some of the codes because of the broadness associated with that code A, right?
Yeah, in every proposal for decision, there's essentially a preamble where the judge explains in prose what their decision was, and then the findings and conclusions. And that last paragraph of her preamble explicitly says, subsection G took this 401(2)A power out of my hands, and I can't, I have to put my fingers in my ears. I'm not going to render any decision on it. Oh, and also, it doesn't apply, even if it did apply, it doesn't apply to current licensees. And that's about as much as she talked about it there. If you don't change at least the preamble, that section sends a very strong message that seems to be against everything else that's in all of those cases I've laid out of decisions that supported 401(2)A being used without any controversy.
Right. So the case itself stands, but is there, and Brad, maybe this is for you, is there an opposing opinion to that preamble? Just because this is more of an academic question, I guess. Is that the accurate?
Well, the opposing view was the ALJ's
Opposing
reasoning, which is in, as Trevor pointed out, it's in the analysis portion of the PFD.
But she saw it as superfluous, just too much. It's just additional. She didn't see it as something that, my point is there any consequences beyond what he's stating in adding this to the preamble?
There's no practical consequence in this case. I think what the prosecutor is putting forward is whether there are implications for future cases. My take on that is because it's not addressed in the findings and conclusions that you would adopt as part of your order, it doesn't seem to set any precedent that you can't use this section going
We're not
forward.
nullifying the section because it's not in the conclusions of law, basically.
Yeah, that's sort of my take on it.
Okay.
But if you want to send a signal or a message that the commission believes this section can be used to deny or revoke a license, as the prosecutors
Okay.
very cogently argued, then we can address that one of the two ways.
Just by
Either
adding the preamble.
either adding the conclusions or making that statement in the preamble to your order to kind of rebut the ALJ's argument. Either way, it doesn't change the outcome or result in this case.
You guys good with it? You're comfortable? Yeah. Commissioners? Okay. All right. I just want to make sure, because this is a little convoluted, a little academic. I want to make sure we go through this as much as possible. All right. I'm a simple man, so use small words. All right. Any motions or any other conversation?
So what we want to do is,
To make it very clear, Mr. Chairman, is that what I would like to see happen is that we accept the revocation of this license due to the disorderly conduct and of what happened with the merits of the case, but then also add the proposed additional conclusion of law that was just handed by the treasurer. That is my motion.
I guess, accept the PFD with the addition of the preamble.
Correct.
That's stated here.
I just want to make sure I'm going through Brad and make sure I'm saying it right. Well, what my intent is to accept the revocation and then the addition of the preamble.
And I would just add to that, Commissioner, that the commission believes the ALJ erred in not interpreting
this
this section of
So
law
moved.
correctly.
Yes.
Okay, do you, hang on, just give me, do you want him to read into the record the conclusion of law? Proposed additional conclusion law?
I think it would probably be best to do that because it's not already. And would you like me to, I can, if you'd like, I would offer to read, or maybe Trevor can, and then you can just.
It's up to the
You can
commissioner.
just
Would you like him
incorporate
to do it,
that
or
in
you
your,
wanna do
in
it?
your motion.
I'll read it real fast if you want me
Okay,
to.
it erred in the conclusion by not adding that. That's,
Correct.
we're gonna amend the PFD.
Yes.
Is that, okay, okay.
For clarification, we're going to amend the PFD in error of the ALJ conclusion. We're going to add by these additional conclusions of law as follows. A conclusion of law should be added, which should read, the department may deny, revoke, or suspend a license if the person lacks the honesty, trustworthiness, or integrity necessary to hold a license as contemplated by the Texas Occupational Code 51.4012A. The department may take action under this Texas Occupations Code 51.4012A, even if the action is not accompanied by an allegation that another statutory power belonging to the department justifies denial, revocation, or suspension. The department may take action under Texas Occupation Code 51.4012A against any person, including current or expired license holders. 2. A conclusion of law should be added, which should read, an allegation by the department that person lacks the honesty, trustworthiness, or integrity necessary to hold a license as contemplated by Texas Occupations Code 51.4012A is contested case under Texas Government Code Chapter 2001. Evidence relevant to whether Texas Occupation Code 51.4012A applies may be presented in a contested case under Texas Government Code Chapter 2001. And finally, a conclusion of law should be added, which should read, the preponderance of the evidence, namely the details of aggravated assault with a deadly weapon offense demonstrated by Mr. Lee, lacks the honesty, trustworthiness, or integrity necessary to hold a license as contemplated by Texas Occupations Code 51.4012A. Mr. Chairman.
We have a motion. Is there a second?
Second.
All right, discussion? Brad, you need to add something?
Mr. Chairman, we'll adjust the numbering as appropriate
Okay.
to add those
Okay.
conclusions of law if that motion succeeds.
All right, any other discussion? Any questions? All right, all those in favor say aye.
Aye.
Opposed? Motion carries. Thank you, Mr. Dean. All right, we're gonna go one more, and then we're gonna have a little break, so let's go into this motion for rehearing. Barbara Carmona, and have you filled out, Tamela, do we have their request? You do? Okay, we need to get you to fill out a form, so let me read this to you real quick. If you're here today for motion rehearing, we used to speak to the commission, you'll call up, right? Make sure you fill out the public comment. If you want to speak, make sure you turn that in, state your name into the microphone. Go from there. All right.
Thank you, Chairman. Commissioners, my name is Doug Jennings, Assistant General Counsel for the Department. Before us today, this matter resulted from a default order in which the Department assessed administrative penalties against the respondent in the total of $34,000 and revoked 3 of respondent's licenses. Those are her tow company license, incident management tow operator license, and vehicle storage facility license. The administrative penalties and revocations were based on the respondent allegedly performing a total of 36 tows and operating a vehicle storage facility while not holding the legally required insurance. Just to give you a little background as to how this case originated, it was initiated after a complaint was filed about the respondent's activity. The department's investigator was in constant contact with the respondent prior to the filing of the notice of alleged violation, repeatedly requested information from the respondent regarding the status of her insurance policies, requesting copies of insurance documents. The respondent never provided authoritative documents, attached a couple of attachments which you will see affixed to the motion for rehearing, one which it appears to be an email from an insurance representative saying that a status of insurance was sent to TDLR a couple of weeks prior to that email, which I believe was dated June 22nd of last year. And second, attached to the motion for rehearing is a scanned image of a printed email which appears to be a request for reinstatement of insurance coverage, but is not a certificate of insurance or any kind of statement saying, yes, your insurance has been reinstated. The investigator also spoke to a representative of Germer Insurance Company to verify that the respondent's policy had been canceled for non-payment. On December 3rd of last year, the department contacted the respondent by phone This is after the notice of alleged violation was filed and mailed to the respondent. The department contacted the respondent by phone to let her know that the NOAV had been filed, but that no response had been received. The respondent was then informed of her right to request a hearing and was also emailed copies of the case documents. Lastly, on January 24th, I emailed opposing counsel requesting information about asking the respondent to provide information or an assurance or some sort of document proving that she had carried all of the legally required insurance during the time of the alleged violations. I have not received anything at this time. The motion for rehearing essentially claims that this case arose from a series of unfortunate errors, of communication errors. One allegation is that the insurance company mailed documents to TDLR that were not processed. Through my review of the case, I was unable to find that any of those documents were actually in the file or received. But I do know that based on my review of the call logs and the email logs in the case, we reached out to the respondent a number of times, actually assured the respondent, if you're able to provide us this information if you're able to give us the insurance documents, we will proceed a different way. It's just my opinion after reviewing the record that the respondent had ample notice, was requested many times to provide the insurance document, and has not done so. And before I close, I will just mention this is the third default order since 2017 in which allegations in whole or in part, which contain allegations in whole or in part that the respondent lacked legally required insurance at the time of some event. So this is not a brand new subject for this respondent.
Okay. Any questions for Mr. Jennings? Okay. All right. I don't have your form, so I don't know. I apologize. All right, Ms. Carmona. Thomas Just?
Yes, sir.
Okay.
I just want to add a few things. Nothing that he said was particularly wrong. Since emailing back and forth with opposing counsel, I have repeatedly tried to reach out to the insurance carrier, unfortunately to no avail. I've been told that they would provide me with documentation. I've been asking for it. It has yet to be forthcoming. What was previously submitted, as opposing counsel noted, were documented emails of my client emailing the insurance carrier asking for proof of being reinstated and submitting to TDLR those records. As opposing counsel noted, there's no evidence necessarily that the insurance carrier did actually follow through on what they were supposed to be doing. I would ask that you not hold that against my client. My client has been trying to do everything that they can to comply with carrying insurance. Unfortunately, the carrier group in this particular case has been less than helpful. To this day, I still do not have the documentation from the insurance carrier that they promised.
Okay. Any comments, Mr. Bell? You good?
No, sir.
Okay. Commissioners?
I have a question. Do you have any proof of receipt of having insurance? Do you carry a policy that you can look and see and look at the dates? Because as being on another large insurance company, I know that there's also receipts and there's also communication that go between insurance and the provider.
Like I said, I have been asking for the insurance company to hand that over to me, and that has yet to be forthcoming.
Well, Mr. Commissioner, I got a question too. I mean, do we have canceled checks? Do we have bank statements that show money was withdrawn from the account? I mean, where's the proof that it was paid for?
If I may, Commissioners, I would note, just so we have kind of a background of the posture of this case, a default order was issued in this case. There was no SOA hearing. The respondent was informed, both via postal mail, given notice of the alleged violations, and via email and via phone, given the opportunity for an evidentiary hearing at which she could have presented things like canceled checks, copies of insurance documents. And I just will also note that well before the NOAV was filed, the respondent was asked to provide insurance information. And so that you can see this is a process going back to maybe August of last year. Now, I have no basis to contest opposing counsel's claims about the slow pace of the insurance company, but at the same time, these are documents that could have been requested in August of last year and haven't been, which leads me, I won't advise you, but leads me to the conclusion that maybe they didn't exist. We had an opportunity to present evidence that these documents did exist, that coverage was in place, a hearing was not requested, and therefore it's my opinion that this is not the proper place for an evidentiary hearing, since one could have been held on this matter.
Okay, and I'll defer it. I'll withdraw my question on that, since it wasn't part of the original hearing.
And the idea is simply whether we should allow this to be reheard. If you will, that's the goal. I mean, you feel free to ask the question to generate that. I don't think we need to talk about the presentation, but that's within our purview to decide whether we need to rehear it or not.
And Commissioner, if I may, once again, just to refocus, a motion for rehearing is an opportunity for the respondent to show where TDLR has made a mistake. And after my review, I do not find that we have made that. We have made an error or a mistake. So we would recommend denial.
I'll agree with that, because it seems like there's been plenty of opportunity. We just haven't had.
Any other questions?
I was, Mr. Just, do you think that we as a commission have made a mistake in this case?
I think that in this particular case, I don't know that I would put the particular blame on TDLR, but I do have record of payments that I can submit to you. But unfortunately, my client's behind, between a rock and a hard place. We have record of payments. We have emails from the insurance carrier that have been provided to you saying that they say that they've sent them in to you. I don't know whether or not they have or not. I have no evidence of that one way or the other. But I can provide record of payment by my client. I've already provided you emails from the insurance carrier. To me, this is squarely on the fault of the insurance carrier.
Thank you.
Any other comments? All right, I'll entertain a motion.
So we either need to make a motion,
Right,
whether
or deny
the rehearing.
Deny or allow for rehearing. Give me the timeline again, just one more time. I want to make sure I understand the time. It was August?
Yes, the NOAV was filed. Let me get my document. The NOAV was filed on October 17th of last year.
Right.
And I believe the communications with the respondent stretch at least, perhaps before August, but I know that is a date certain.
Okay. And there was interaction?
Yes,
It was
between
not
Ms. Carmona
Correct.
and a department investigator, yes. And I know we have email logs of those communications,
Right.
and I believe a few phone logs.
You mentioned 2017 earlier.
Yes.
So why does it go, what's going back that far?
There was I can't give you the specifics about that case. I haven't looked into it. I just know in our NOAV, the prosecutor mentions that in 2017, and I will get it for you, in case numbers TOW 2015-002-1103 and TOW 2016-002-3121, and another VSF case with a long number, TDLR issued a default order assessing respondent an administrative penalty of $6,200. Part of that dealt with failing to maintain insurance. There was also an allegation of removing a vehicle from a parking facility without authority, and some charging of additional fees. And there are a couple of other default cases, I believe in 2018. One other case in 2018 where there was an allegation of insufficient or not carrying legally required insurance. So this would be the third time this issue has arisen with this respondent.
My understanding is that many of those particular notices were sent to my client's old address, and so there was an address change, and so there was a delay in getting some of those notices.
And I won't, I
We can't
see no
press it.
comment.
There's no
I'm not going to
default.
contradict that. They were default orders, so those could have arisen a number of ways, and I haven't looked into the merits of service on those. I just wanted to raise the point that this is not a new issue, at least as far as the record shows for this respondent.
One more clarification point from me. Did you think, in your honest opinion, did you give the opposing counsel enough time to get you information relating to having full coverage insurance for her towing company?
I sent an email to opposing counsel on, I believe I have it in my little notes here, on, I think, yes, January 24th, sorry. And I asked for, I gave a week. And the reason for that week is that we had to have commission materials prepared right after that week date would have hit. Counsel had already provided a couple of things, as you see in the motion for rehearing, and so I just assumed that would be sufficient extra time, and that was kind of an extraordinary practice. For me, I typically don't, just as far as my practice goes, I typically don't request additional documentation, but when there's an allegation that there may have been some error in communication, that there could potentially be a document somewhere, I wanted to go ahead and lay eyes on that so I could better advise the commission. But yes, I do think, in my personal opinion, that was ample time, particularly because requests for this coverage had been ongoing for some time.
I will say that I was brought into this case fairly late, and I have tried to move as expeditiously as possible, trying to get proof from the insurance carrier of coverage. Unfortunately, I have been unsuccessful in getting anything out of them.
Are you saying that there was never a lapse in insurance coverage?
That is my understanding. But unfortunately, every request from the insurance carrier from me up to this point has not been successful. I have not gotten, including my clients, we've called, emailed, carrier pigeon, everything we can, and we've gotten nothing out of them.
Well, Mr. Just, what's concerning me is that if this was the first time, I would totally understand. But this being the third time,
right,
and it's very concerning for me because you have not really shown me why we need to have another rehearing. I'm just being honest.
No, I understand that. What I would point out to you is I would point to the email documented that we have, right, where the insurance carrier says that he has sent the documentation to TDLR, right? In other words, my client at that point thought that she had done everything that she needed to do in order to comply. I'm not here to sort of relitigate every other past incident. All I can sort of address to you is the case at present. And in this particular case, she had email documentation from the insurance carrier in which he stated that he had sent everything to TDLR. Now, I can't verify whether or not he did that or not. But, in this particular case, we're trying to do everything that we can to get that documentation. We've just been unsuccessful to this point.
But to that point, they didn't send copies of the information that they supposedly sent to TDLR, right?
That's correct.
Okay. I'll make a motion to deny the rehearing.
Any more? No, second?
Second.
Any discussion? My petition is, the insurance company is not in the vehicle storage or the towing business. The client is. There's a fiduciary associated with that, so it's a big point. Any other comments on the motion? All in favor, say aye.
Aye.
Opposed? Motion carries.
Thank you, Commissioners.
Ms. Jennings. Thank you, Mr. All right, we're going to take a 5-minute break.
Good morning, Molly Feudel, Assistant General Counsel, here with you again. I'm here to talk about some proposed rules for the Industrialized Housing and Buildings Program. We call that IHB. These rules implement two bills from the last legislative session. One was HB 1385, which removed the height limit for industrialized housing and buildings that fell within our program. So previously, there was a height limit of 4 stories. If a building or housing was taller than that, it fell outside of our program. But now that restriction's been removed and it's unlimited. The second bill that these rules implement is HB 2546. And this bill allows IHB manufacturers and builders to construct single-family modular housing in accordance with certain amendments to the statewide energy code. These rules also contain some cleanup and clarification changes designed to make the rules easier to understand. These proposed amendments were published in the Texas Register for comment on November 29th of 2019, and the comment period closed on December 30th. We received comments from 3 interested parties. I'll give you just an overview of those comments. There was one comment that there were concerns that the rules imposed new inspection and testing requirements, but they actually don't. They are just rephrasing it. There was a concern that the rules wouldn't allow manufacturers and builders to work with third parties on fire suppression systems, but these rules actually don't prohibit that. One commenter disagreed with the rules because the rules regulate equipment shelters for electrical equipment and other buildings at petrochemical facilities. Essentially, the commenter commented that the department doesn't have authority to regulate these, but we actually do. The statute, the IHB statute, does not have an exemption for those buildings, and these rules that are before you are fully within your rulemaking authority. There was also a request for a 6-month delay so that others could present more comments. However, these are bill implementation rules, so we feel it's really important to get moving on them as the statute's already effective. And as well as that, we had the 30-day comment period, only received 3 comments, and these were presented to the IHB Code Council twice. So no changes were made as a result of these comments. As I said, the Industrialized Building Code Council met on January 9th and reviewed the rules. They didn't recommend any changes based on the comments, but they did recommend a change independently. And those changes are in 70.23 and .24 regarding the qualifications for third-party inspectors. Essentially, when these rules were published, they recommended, or the qualifications for becoming an approved third-party inspector were ICC certification as a fire inspector, excuse me. The Code Council recommended that we also accept NFPA, National Fire Protection Association certification. The reason why is because if you have the NFPA certification, you can transfer that certification to ICC simply by paying a fee. So this change would allow those inspectors to be able to inspect for the IHB program without having to pay that fee. And it wouldn't affect the public safety aspects of these rules at all. So the department recommends those changes. And 2 additional changes. One of them is to 70.101, just correcting a typo that occurred in the publication of these rules. And the last change that the department requests is to 70.70C9. I believe that was passed out to you this morning. This is not a substantive change, but it's something that we think will make the rules much easier for the public to understand. And the department recommends an effective date of March 15th, 2020. So I'm here available for any questions that you might have.
Thank you, Molly.
Thank you.
Any questions? I entertain a motion.
Make a motion to approve new rules.
Second.
Any discussion? All in favor, say aye.
Aye.
Opposed?
Thank you.
Okay, we're going to switch L and M. We're going to go to item M, which is the cosmetologist, and Colleen is Tran. This is where we're going to do public comment. Misty Benavides. And then Jennifer Smith, if you want to come on up too, you're welcome. Is there anybody else on cosmetologist? Is that it? Okay. It'll be 3 minutes. We can't respond to anything, just other than you talking to us, if you don't mind. And Brad, would you mind keeping time? Okay.
Okay.
Benavides, go ahead.
Yes, my name is Misty Benavides, and I am here on behalf of Tony and Guy Academies and DFW. We have 5 items we'd like to comment on. One, with the adopted changes to the hours requirement for cosmetology, we ask that clarification to all questions be released as soon as possible, as prospective students are aware of the coming changes and it has become more difficult to address and causing hesitation for enrollments. We would also like to request clarity on how current students will be handled once we offer the new 1,000 hours requirements. As it is now, we are enrolling for 1,500 hours for March. However, the students will reach 1,000 hours in September before completing the program and can then drop before completing the necessary education to take their state board test within our program. Number 3, if we can get clarity on when we are implementing the new requirements to begin enrolling for this new program, which also leads to the question of when we will be receiving approval from the state, the certification, so that we can then, submit that to our accreditor to be able to offer this program. And last, we would like to ask the board to consider allowing schools to offer 1,000 hours as well as 1,500 hours for those students who would like to continue their training and practical experience within our program.
Okay.
Hi, my name is Jennifer Smith. I'm also here on behalf of Tony and Guy, Hairdressing Academies at DFW. Just want to kind of talk about one issue that we're foreseeing as a private post-secondary cosmetology school. We have to have accreditation to offer Title IV funding through the Department of Education. Part of that is our accreditors will not approve a 1,000-hour program for us until we have an official state approval. We've already been informed through email from TDLR that we're supposed to move on like everything, like we're already approved, but we can't get funding for our students if we don't have an official approval. So if we can get that process moved forward quicker so that I can get Title funding, Title IV funding for students, that would be the best thing for, because we don't want to hurt our students. We don't want them to lose funding, and we don't want them to be out of pocket and have to drop out of school or not be able to go take their test because they can't finish school. So
Is there anything else?
I think that's all.
Ladies, thank you
Thank you.
so much for what you do. Thank you for your information. We so much appreciate it.
Thank you.
Commissioner. Ms. Tran.
Colleen Tran, Assistant General Counsel for the Cosmetology Program. Good morning, Commission members. Thank you. We're going to go over Agenda Item M for the Cosmetology Program. So the proposed rules to Chapter 83 implement necessary changes from House Bill 2847 from this past session. As required by House Bill 2847, the proposed rules lower the number of hours required to obtain an operator license from 1,500 to 1,000. It increases the inspection cycle for establishments that provide certain services and provides for the regulation of remote service businesses and digitally prearranged remote services. The proposed rules also include recommendations made by the advisory board work groups to reduce regulatory burdens and provide more clarity to the industry by using more updated and standardized terminology. On October 21st, TDLR held 2 summits, one for Barber and one for Cosmetology, to discuss House Bill 2847 and the impact that the change from 1,500 to 1,000 would have. Specifically for the Cosmetology Summit, we looked at, because the law changed and it needs to be 1,000, we looked at different curriculum standards, the breakdowns, and looked what an allocation of hours should be for each curriculum standard that they would have. Staff considered hundreds of comments and suggestions on what the breakdown for the hours should be for the 1,000, and we put those options before the Cosmetology Advisory Board on November 18th, 2019. So after discussion, the Advisory Board suggested one option, which is the option that was in the proposed rules, and they can for the curriculum standard, and they voted that the rules be published in the Texas Register. Those rules published on January 3rd. That public comment period closed on February 3rd, and the department received 133 comments within that 30-day public comment period. So quickly, because of the volume of the comments, we had to group them. So we grouped them, and the comments ranged for people who were against the 1,500 to 1,000-hour change. And the response to that is that it is a law change that we had to do, and so the change is necessary because we have to follow the law. Some comments were specifically from students on how the rules were going to affect them personally. And then, as you heard here from schools want to know how the change is going to be implemented. So a lot of those comments came in about how is it going to affect me, what am I going to do, and how the schools need to be implementing it, which were not specifically about the rule change. And a lot of the other comments were outside of the scope of rulemaking. The advisory board for cosmetology met on February 10th to discuss the proposed rules and the public comment. The advisory board recommended adopting the proposed rules without changes, and the department recommends that the commission adopt the rules without changes with an effective date of March 15th, 2020.
Thank you for your work on this. I know it's an extraordinary task of what you've done.
Thank you.
You said it very quickly, but I know the efforts and the amount of comments and the energy that was around this issue is extraordinary. So thank you so much and your
Thank
staff
you.
for doing
Appreciate
it. Any comments or questions, commissioners? I just have a couple. One is there was a question that was posed about the 1,500. If you somebody still wanted to take that as an option.
So the law only says that you would need 1,000 to get a license. This law doesn't dictate what a school has to actually teach. So to attain a license, you need 1,000 hours. It doesn't dictate that a school cannot teach 1,100, 1,200, 1,500, 2,000 if they wanted to. But you're only required to have 1,000 to obtain a license by law.
Okay. And then the funding, the official state approval, is that?
It is my understanding that Education and Examination has been working with the Department of Education and NACIS. There's national accrediting for cosmetology schools. So I would advise them to speak to our Education and Examination division specifically.
Okay.
So that would probably take effect on this March 15th when these go into effect.
I assume so, but I would defer to E&E.
Mr. Chairman, Brian Francis, that's exactly right. We were waiting for this decision to finalize the 1,000 hours so that we can move forward.
Okay.
But we've already been having preliminary discussions with Ray and his team and DOE.
Would they be able to get the funding needed, those students?
They're going to get their approval. This is not the first time that a state has changed from 1,500 to 1,000 hours. It just happened quicker than we had anticipated. We thought it was all going to take place on September 1, and it got moved up to September 1, 2019-ish. So it's just this moment in time, this blur in time. But ultimately, they're going to catch up to it, and we're going to move fast with, working with DOE and provide them with the curriculum. But they have already approved, I think Maine and New York already have 1,000-hour curriculum, so this will not be foreign or new to them.
I have a question. Just based on whenever you have programs, just like me, when I went to medical school and residency, there's certain curriculum you have to pass and certain things you have to do. My concern is to say that there's hair, there's nails, and then there's facial stuff. Say they've already done 800 or 900 in hair, and they haven't really done enough on face, or they haven't done enough on nails. What's the justification of stopping at 1,000? I'm just trying to make sure that they're educated throughout the whole process. I do agree with eliminating the total number of hours, but not at I'm very concerned about these people that are in the middle that have a curriculum of 1,500 and now they're dropping to 1,000. We're just going to say you go out and practice with 1,000 and not being experts in the field of what they need to be understanding.
Well, keep in mind, there's a couple of things that they would have to clear in that moment. Number one, they have to take the examination and pass it.
Correct.
So that examination becomes the ultimate measure of competency. We've sent out an information notice back in December letting the schools know that, and in the rules it includes language that says if you've had students that enrolled after January 1, because usually a program lasts for 9 months. They can't pass for more than 9 months. So if you have a student enrolled after January 1, we've provided a path for that student not to be harmed to transfer those hours to the 1,000-hour course. So we've tried to factor that in to this scenario. The other thing is that you could have a person who's in a 1,500-hour course today, finish that in July, and they can take their license, they can take their examination and their license, and go on with the rat killing, as I like to refer to it. Their world hasn't changed for them. This is simply saying that beginning on September 1, 2020, you can now get your license for 1,000 hours, but it doesn't change the 1,500-hour requirement going back this direction.
I just wanted to make it very clarification, since we're live and in public
Sure.
as well, is that I want to make sure that we're protecting all Texans.
We've got to take care of the students.
Right, and make sure the students are taken care of. That's all I'm asking.
And that's exactly, and my team knows that we've had a couple of meetings, and that's the first thing I came to the meeting and said, we're going to take care of the students. And sometimes the schools are in a tough lurch because they enrolled students in January, and they'll have a new class coming in September. But the rules have been crafted in such a way that we do as little harm to the students as possible. But there is always this odd moment when you have a change in law and there's a line, somebody is going to be on this side. They just are, and that's what this one has. But once it's in place, it's going to run, and Ray and the IT team have been working really hard to get the system up in place to convert the 1,500-hour courses over to 1,000 and to make sure that those students have the best opportunity to be successful.
Ms. Trent, we at TDR take every license at exceptional level. Is there anything you're lacking at this very precarious time as far as information or resources? Because you're at a very arbitrage type time, which Director Francis talked. I just want to make sure, is there something that we can provide to you to make sure that questions and these things this season comes up?
No, I think I'm good. I would be remiss if I didn't say it's not just me that's been having to take in all of the information and the input that's been getting. There's a huge team, RPM, E&E, licensing, IT. We're all coming together. We're looking at every comment. We're trying to respond, and we are not afraid to ask for help if we need it. So you will hear it if we need it. But I think right now we're in a good spot and working through it all.
I can't emphasize that you do ask us directly of any resources that we can in this special time, okay?
Will do.
Any other questions? All right, I'll entertain a motion.
Make a motion to approve.
Second.
All in favor, say aye.
Aye.
Opposed? Motion carries. All right, we're going to go to L, which is the Barbers. Jensen?
Mr. Gladney? We're doing L.
Yeah, I'm just waiting.
Well, we're going to
Somebody's
have,
gonna
we have
sit
one
there
public
just-
comment. Mr. Jensen.
Thank you for queuing up so quickly, though, sir.
You get an A for effort, I'll tell you
Hey, I'm
that. A
anxious.
for effort.
Very, very fast.
Mr. Ron Jensen? Is he here? Junior? Oh. So, you'll have
morning.
3 minutes. Good morning, Mr. Thank you for coming. I
Yes.
appreciate your time. I know everybody's busy. Thank you for adding to this. You have 3 minutes, and we can't interact. We'll just listen to your.
All right. Thanks a lot, Mr. Chairman. Good morning, Commissioners. My name is Ron Jemison Jr. I'm the owner of a Franklin Barber and Beauty Institute in Houston, Texas. I'm here today to comment. I'm for the reduction of the Barber program to 1,000 hours from 1,500. Over the last 30 or some odd years, the cosmetology program and the barber program have been equal in hours. We have the barber industry, as you know, and you see the commercials around the world and around the state, has a resurgence and has come back alive and is doing very well. We see licensed barbers making better income, should I say, and being able to have very productive lives. I see that if we do not match the hours of the cosmetologists from 1,500 to 1,000 as well, then I can see a decline in the number of barbers that become licensed in the state of Texas due to the fact that, as you know and I know, there's online classes, there's all types of things that everybody gets at their fingertips now with apps. Our food comes to us, besides Pizza Hut. We've still got other types of deliveries that we're getting now. You don't have to even get out of your seat at the stadium and somebody will bring you some food. So everything that's been done is kind of coming in a rapid pace. The students are still going to be able to engage and get the same amount of information in that amount of time. And as what we want to do is we definitely want to protect the consumers of the state of Texas as well. I like what Commissioner said earlier. I heard your point, and basically we want to make sure that if we're reducing the hours from 1,500 to 1,000, that we're still giving adequate education to our individuals, that they are protecting the consumers of the state of Texas as well by protecting them with health and safety. And I know that that can be done as well. I just want to make sure that the barbers are not left out, because I don't want to see a decline in barber schools where they will go away, because a person can go to a cosmetology school, in which I do have both, so I'm on both sides of the fence, but a person can go to a cosmetology school and take a 1,000-hour course and become licensed to actually work for less time than if they went to a barber school for 1,500 hours. And if you look at the curriculums, they're very similar, really very similar. So I just want to make that comment. I know that there's a lot of young men and women out there that want to follow in the footsteps of their grandparents and their parents and generations to come, and they want to become a licensed barber. They might not want to be a licensed cosmetologist labeled by the state of Texas. Okay. And so also I see that I was watching something, I saw Governor Abbott wants to break down some of the barriers. He said, let's tear down some of the barriers we have. So I feel that if we do not reduce the barber hours to 1,000, then as the cosmetologists have done, cosmetology industry has done, then I just see a decrease in the licensed barbers that we have today. Thank you.
Thank you for your time and your school.
Thank you.
Thank you.
Any questions?
We can't have.
Oh, good.
Ms. Tran.
Sorry, I thought there was more.
No, that was it. That was it.
Okay. Colleen Tran, Assistant General Counsel for the barbering program as well. So the rules that you have before you implement House Bill 2847. In House Bill 2847, for the barbering program, the proposed rules increase the inspection cycle for establishments that provide certain services and provide for the regulation of remote service businesses and digitally prearranged remote services, which you've already seen with the cosmetology program as well. The difference here is that barbering's hours for a Class A barber license is not in law. It's by rule. And so therefore, the commission can decide what those hours need to be. In October, as I said earlier, we held a summit for barbers and cosmetologists. In the barbering program, the summit focused on the change to cosmetology from 1,500 to 1,000, how that would affect the barbering program, and if the barbering program were to go to 1,000, what would that curriculum look like? So from the comments received, staff considered all of those and the suggestions. We provided options to the advisory board at their November 4th meeting. And those options included various, so if it was to stay at 1,000, if it was to stay at 1,500, go to 1,000, or 1,100, or 1,200, or 1,300, or 1,400. We gave them all the options possible and what those breakdowns could look like. The advisory board considered them, had a discussion, and voted to propose the rules with the change from 1,500 to 1,000 for public comment. Those proposed rules were published in the Texas Register on January 3rd. The public comment period closed on February 3rd, and the department received 76 comments. And they were also bucketed similarly to cosmetology. We had people who were for the change, people who were against the change, but a lot of the comments came in, how does this affect me? These are my current number of hours. And schools wanting to know how they can change or adjust. And then there were a fair amount of comments that were just completely outside the scope. The advisory board met on February 10th to discuss the proposed rules and the public comments. So at that particular meeting, the advisory board recommended that the commission adopt the proposed rules without the change to 1,500 to 1,000. So the inspection cycle, the cleaning up by the work group, and the remote service business rules. The advisory board took a vote on lowering 1,500 to 1,000, so on that particular change that was proposed, and it split 2 and 2. So therefore, they failed to make a recommendation on that particular issue that's now before you as the commission. Yes, sir.
You got a quick question? Go ahead. No, after you're done, I'm going to ask a question for you.
That's actually where I'm done.
Oh, you're done.
So then, and now those options are before you. Rules as proposed, or the change to leave it at 1,500, or any other hours that you see fit.
First, it's probably going to be addressed to you, Mr. Francis. First, I want to thank you for coming and spending your time here. I always think that competition is very, very good for lowering market standards, for making our students work where we have complete integrity with our whole cosmetology and barber program. Meaning that if you do level the playing field, then you'll have both barbers and cosmetologists coming out, which I think Texas needs. My question to you, we're still going to maintain students being educated, correct? Going
Yes,
to
sir.
1,000 hours. Texans are still going to be protected in order to do inspections, and we're going to still have strong barbers coming out. And
Yes,
the
sir.
final thing I want to make sure is that even though it was a 2-2 split, I feel very strongly in order to maintain a strong barber and cosmetology, we shouldn't level we should level the playing field. So do you, are those easily achievable?
They are achievable, and it's, just the tradition of the barbering program makes it tough to hear that. But one of the things that I've just not been able to reconcile in my head is how the barbering industry in schools will survive if a person can go and become an operator at 1,000 hours, take the 300-hour crossover course, and become a Class A barber and an operator before you finish your 1,500-hour course. We live in I want it now society, and I think people are going to want those two things before they can get the one thing. The education curriculum that the barber group has worked on, we sent it to their educators to ensure, one, that sanitation is woven throughout that. We did not discount sanitation at all in the health and safety of Texans, but we also made sure that the educators in that industry said, here are the allocation of hours that will still make our students successful and competent and allow them to compete when they get into the business. So answer to your question on yes, sanitation is at the forefront for consumer protection. Yes, the students are going to have education. There's going to be an adjustment period. It's going to be a lot of work on these schools to figure out and change the way how they teach the information, but they're going to teach that same level of consistency and appropriateness through that, and the competition is going to be there if it's lowered.
Thank you. Thank you, Mr. Chairman.
I have a motion if there's no other comment.
Just real quick.
Yes, sir. Yes, sir.
I'm excited. I think that we as an industry, there's always an evolution. We can always do things better, more efficient, efficiencies associated with. I'm excited about what TDLR's been tasked with. Again, I'll restate the question or the statement. If there's any resources that you're lacking in regards to this transition, you let us know. We want to fully lean into, especially this season of arbitrage where there's a change that's occurring. With change, people get a little scared or there's just a lack of information.
Yes,
So we
sir.
want to make sure that we are way ahead of that curve as
Yes,
much
sir.
as possible. So whatever you need, you let us know.
Yes, sir.
We understand that timeline is short, but we'll lean into as much as we can.
Okay.
But thank you so much for the effort. And
Right.
I will let the executive director know as well, that the legislature's trusted us with a lot of different things. And I'm excited about that. And we stand up tall every time. I'm proud of your staff and what you guys do as a group. And I know there's people behind you that aren't sitting at that table. Please, on behalf of the commission, thank them.
Will do.
Personally thank them for
Yes.
us, because we know the nights and the efforts were
Yes.
many. So thank you so much.
Thank you, Mr. Chairman.
Yeah, I want to make a motion, Mr. Chairman, that we accept everything that the lead counsel recommend as to oversight and governance, but also to reduce the hours of barbering from 1,500 to 1,000. And I firmly believe that's the right move, and thank you for accepting my motion.
Second? Second. Any discussion? All in favor, say aye.
Aye.
Opposed? Thank you, Mr. Chairman.
Thank you, Colleen. Appreciate it.
All right, we are going to move to N, driver education and safety. Mark? Your time to shine.
Okay. Good morning. For the record, Mark Lively, General Counsel's Office. I'm here to present the proposed amendments relating to existing rules at 16 Texas Administrative Code, Chapter 84, Subchapter D, Section 8450, Subchapter M, 84.500 and 84.502, and Subchapter N, 84.600, regarding the Driver Education Safety Program, or the DES program. The proposed amendments are necessary to implement House Bills 105 and 2048 in the last legislative session, which modified driver training course curriculum and clarify eligibility requirements for parent-taught driver education course instructors, or PTDE for short. These two the rule changes have been combined into one proposal to ensure that the rules to implement the curriculum changes to driver training courses pursuant to HB 105 are adopted by March 1st, 2020, as required in the bill. The proposed rules were published in the Texas Register on November 8th of last year. The public comment period closed December 9th. The department received one comment during the 30-day public comment period and one late comment. The Driver Training and Traffic Safety Advisory Committee met on December 18th to discuss the proposed rules and the public comments received. The committee didn't have a quorum on that particular day. It was a week before Christmas, and therefore could not take any official action on the recommendation to adopt the proposed rules. The rules, however, were discussed in the open meeting, and the department did recommend a change to one of the sections, which I'll get to in a few minutes. The proposed package was discussed with the members who were there, and the package, there was no objection by the members that were present at that particular time. Now, as I said, there was a change recommended by staff to 84.500C2 for clarification purposes, and this came about as a result of a comment that we received because there was some confusion as to what violations would invalidate a driver education instructor trainee who was seeking to take the instructor development course to become a driver education instructor. And HB 2048 invalidated or repealed the driver safety responsibility program in Chapter 708 of the Transportation Code. So basically it got rid of the point system. So if you got a moving violation, you would get points, and if you accumulated so many points, you could end up getting your license suspended. But HB 2048 got rid of that and created a slightly new regime that applied to the parent-taught driver education instructors eligibility requirements, and added in some criminal violations and some moving violations, mainly if a person who wanted to be a PTDE instructor, if they had 3 moving violations without a license, without an accident within the 3 previous years before they wanted to become a PTDE instructor, that could invalidate them, or 2 moving violations if they involved an accident. So that was added into the language in 84.50 along with the criminal violations that would invalidate someone who wanted to be a PTDE instructor. Now, because Chapter 708 of the Transportation Code was invalidated by HB 2048, 84.500C2 referred to a statute, a chapter that no longer existed. So staff had to find a way to allow an instructor trainee in an instructor development course who wanted to become a driver's education instructor to be able to qualify. So what staff did was they adopted the moving violations, so that an IDC course owner could go and check the driving record in the previous 3 years and determine whether or not that person had either 3 moving violations that didn't involve an accident, or 2 moving violations that did involve an accident within the previous 3 years. And if they didn't have that, then they could sit for the course. If they did, they would be invalidated. So that was a major change that was made as a result of a comment that we received. The second comment we received was a late comment. It wasn't germane to the rulemaking, so we moved on from that. Staff recommends adopting the proposed rules with the proposed change to 84.500C2 as discussed with the Driver Training and Traffic Safety Advisory Committee. And so we ask for a motion to adopt the proposed rules with the aforementioned change to reference 84.50B3 and 84.500C2 with an effective date of March 15th.
Thank you, sir. Any comments? Questions? Entertain a motion.
Make a motion to adopt with changes.
Second.
All in favor, say aye.
Aye.
Opposed? Motion carries. Thank you, Mark.
Thank you.
Mr. Chairman, Brian Francis, if I could quickly just comment on this. What you've had in your last two commission meetings have been 8 statutory changes, eight bills that required rulemaking, and the staff has moved so swiftly, but also have built in a lot of collaboration, working with the industry groups, having summits in between that time period, working with the different folks in our group. Our agency, as you pointed out, it's not just one piece. You have our RPM and our enforcement division, OSC, education, examination, licensing. All those groups contribute to Mr. Gladney putting on the show up there with his Packers thing on. But anyway, I digress just a tad. I wanted to say that I'm super proud of how thorough and how effective our team is. This is the work that the legislature looks at and says, we passed the bill, what are you doing with it? And we're putting them in place and making sure that these things are enacted and consistent with the legislative direction. So I just want to give tip my hat to the team and what they've done so far.
Extraordinary time. Not to mention the new IT, fuels, a lot of those.
It's a lot moving. There's a couple moving parts there. Sunset.
Concur. Don't blame Sunset now. All right, thank you, Mark. Item O.
Good morning, Chairman and Commissioners. My name is Jessica Hurtado. I'm a prosecutor in the Enforcement Division. And this morning I'm presenting to you the proposed penalty matrix for the Dyslexia Therapy Program for your consideration and approval. The Dyslexia Therapy Program was transferred to TDLR from the Department of State Health Services, and the adoption and implementation of this penalty matrix will bring structure to the program and assist the department in ensuring the safety and general welfare of the public. Just a very brief discussion about what the penalty matrix is used for. Once published, the matrix is used to put the industry licensees and the public on notice as to what acts constitute a violation of the laws and rules for the Dyslexia Therapy Program. It is also used by the prosecutors when we determine that an administrative penalty should be sought in a formal enforcement action. A standardized range for the penalty creates consistency between the prosecutors and ensures similar violations are given similar penalties. And finally, it is a tool used to help the public understand what is a violation of the program laws and rules. Briefly, what the penalty matrix is not. The penalty matrix does not create new law. It simply restates the laws and rules in a sort of plain talk that can be understood by the licensees and the public. The penalty matrix does not obligate the department to impose a penalty if a violation is found. Often prosecutors will either issue a warning letter or otherwise informally resolve a case. In those situations, the penalty matrix doesn't come into play. And finally, the penalty matrix is not binding on you, the commission, when you're making decisions after a contested case has been heard at SOA. Briefly about this penalty matrix in particular, it's broken down into 4 classes, Class A through D, with each subsequent class carrying a higher penalty range than the one before it. Each violation is assigned to a class, and they're grouped together with similar violations. The penalty matrix does use a single range of penalties and sanctions for each class, and the penalty or sanction for a violation must fall within that range. And this is a simplified approach, different from some of our other programs that have first, second, or third violations. We found that this simplified approach is working and is more consistent with agency goals of streamlining procedural steps and ensuring prompt investigation and resolution of complaints. And the last thing you'll see on this particular penalty matrix is the heading standard of care violations. Under the Class B and C violations, when you see the standard of care, that's a signal to the prosecutor that we're always going to need an expert witness to help us evaluate the evidence in those cases, because the evaluation goes beyond the facts of the case and involves an interpretation of whether those facts violate a professional standard. And so the department will use an expert witness in those situations. At the January 27, 2020 Advisory Committee meeting, the penalty matrix was approved unanimously by the Dyslexia Therapy Board. And the division requests that you vote today to approve the penalty matrix so it can be made part of the department's enforcement plan, and I'm happy to answer any questions you have.
I like it. Less is more. Thank you. I think it's beneficial. Any questions?
I'll make a motion.
Good job. Second.
Second.
All in favor, say aye.
Aye.
Motion carries.
Thank you.
All right. Item P.
Yes, thank you, Chairman. Jessica Hurtado, prosecutor with the Enforcement Division. This penalty matrix that we're presenting is for the Behavior Analyst Program. This program was created by the legislature beginning September 1 of 2018, and adopting and implementing this penalty matrix will again bring structure for the program and help us ensure the safety and welfare of the public. This penalty matrix is also broken down into the 4 classes, A through D, and again with a single penalty range. As with the dyslexia therapist, the behavior analyst penalty matrix also has a standard of care violations that you'll see under those headings where the department will be using expert witnesses. For this penalty matrix, it went before the behavior analyst board on January 29, 2020, and it was approved for your to be presented to you today. And so we ask that you approve it so we can make it a part of the enforcement plan, and I can answer any questions.
Thank you. Any questions?
Make a motion to approve the penalty matrix for behavioral analysis program.
All in favor, say aye.
Aye.
Opposed? Thank you, sir.
Thank you.
All right, Q. Bruno.
Good afternoon, Mr. Chairman and Commissioners. It says Eric Beverly on your agenda. He was not able to be here, so I'm going to do my best to step in for him. I'm going to give you an update on the sunset activities of late. We are continuing to have many meetings and data requests from the Sunset Commission. They continue to go very well, and what we're all working toward are 3 big steps that will be coming up before the session begins as part of our sunset process. The next one is that we anticipate that the Sunset Commission will take all of the work that they've been doing, all the meetings they've been having with us, all the information they've gathered, and they will make a report about our agency that's anticipated to come out in June of this year. Already on the Sunset website, we have indications of the next steps, which are going to be a public meeting where TDLR and our report are discussed. And then the next meeting after that will be a decision meeting where the Sunset Commission actually makes decisions about recommendations in our report. So on the Sunset's website right now, there is listed Wednesday and Thursday, August 19th and 20th. We anticipate that on those days, and I would think it would probably be Wednesday the 19th, that will be the public hearing about TDLR, where any member of the public can come and sign up and address the commission, the Sunset Commission, on us, and that will take place, of course, at the Texas Capitol. The next month, it's listed for Wednesday and Thursday, September 23rd and 24th. That will be the decision meeting, where votes are actually taken by Sunset Commission members about recommendations in our report. What's going to happen after that is those decisions will be made, and then when we begin the session in January of 2021, there will be a bill that is our sunset bill that contains all of these recommendations and decisions, and then that'll go through the normal process like any of the other 5,500 to 7,500 bills that'll probably get filed next session.
In a slow year.
Yes, sir.
All right.
So that's where we are right now, and we're feeling very good about it, and I'd be happy to take any questions you all have.
Any comments? Are you liking anything, Mr. Bruno?
No, sir.
Okay. Well, whatever we can do to help. I'm excited about it, and I couldn't have come at a
We are
better
too.
time, Mr. Francis, as we take on these. It's always good to have eyes outside ourselves.
I agree.
Looking at these things, so let us know. I'm
Yes, sir.
excited about it.
We will.
They're very smart,
Thank you.
very thorough.
All right. Q. Tamlin, am I missing anything? We're going to R?
Yes, sir.
All right.
Mr. Chairman, Brian Francis, Executive Director with TDLR. I appreciate the time that y'all have given us today. You've had some really interesting decisions you had in front of you, so I appreciate the effort and the time. I'd like to do 3 things in my report. 1, I'll introduce our anti-trafficking unit. 2, I'll give you just a quick update on the strategic planning process. Then I'm going to invite our Chief Information Security Officer, Victoriano, up to the table to give you an overview of House Bill 3834, and then I'll turn it over to Christina Kaiser. So we were fortunate to get some investments from the legislature in regard to anti-trafficking, and we weren't the only agency. The Attorney General's office received significant funding, the Alcohol Beverage Commission, several agencies were given money to combat human trafficking. I want to make something extremely clear. Before we received this investment, we were already in the fight. Our enforcement division was on the front lines, our field inspectors on the front lines, the General Counsel's office was right there in the fight. Jennifer Harless was an army of one. But now we have some additional arrows in the quiver to really go after trafficking. This anti-human trafficking team is not made of superheroes, they're made of superhumans. Their hearts are huge, they are in the right position to really have that compassion and be our front line for being the first and maybe the only person from a governmental agency that these survivors will see. They're going to represent our agency in that regard. Their goal and their task is very straightforward. Not easy, but very straightforward. We are going to identify every illicit massage business in the state of Texas, and they're going to go into every last one of them. That's what they're going to do. And from going inside of them, they will either make referrals to our enforcement division, they'll make referrals to the AG's office, they'll make referrals to local law enforcement, to our federal partners, or to the NGOs, the non-governmental organizations to help those survivors. And from these referrals, we'll have criminal convictions, administrative actions that may come before the commission, civil actions, and we may have people that are saved. That's their job. It's not easy, but that's what they're going to do. I'd like to introduce the members of this team. Mary Winston, is she in the building? Mary Winston is the El Capitan of this group. Mary, if you'll stand up and show the folks how we do this thing. The team lead is Jennifer Harless. Where's Jennifer? There she is back there. Then we have Ray Carswell, Brian Cottle, Gloria Newton, Alex Ortiz, Jordan Strain, Chuck Winkler, and Jennifer Ignacio. They have been working so hard and trying to, I also need to introduce, where's Colleen? It's Colleen. Colleen's been instrumental in the development and growth of this team in terms of helping formulate the training along with Mary as they go forward. This group has had, oh, there's the claps. So they've been 6 weeks of training. There's 8 members. They've had 256 hours of field training already. 36 classroom hours led by our extremely talented folks in enforcement. Field inspections have been part of that group. We brought folks from licensing to teach them how TDLR does its business. The bottom line is they're going to see anomalies. And if you don't understand how it works in the norm and how its standard looks, you're never going to be able to see that there's a deviation from the process. And so we're teaching them what a standard licensing looks, what a standard inspection should look like so they can identify the anomalies going forward. To date, we've already had collaborative meetings where the folks that come to talk to us with the Office of the Governor, TABC, the City of Houston, their anti-trafficking group, the Attorney General's office. They've done research with the Human Trafficking Prevention Coordinating Group. They participated in a book club, the QBQ, which stands for? Question Behind the Question. Come on, team. That's what I'm talking about. Question Behind the Question. And that's a book that was recommended by Commissioner Collier. And it's just teaching them to really be collaborative. This group is not the answer. This group is the hub that works with our answers throughout the agency. They are coordinating with enforcement. They're coordinating with field inspections, RPM, GC. A lot of folks like, oh, they're doing all the trafficking. No, they're not. They've got a key piece of the puzzle to really gather the information, but they're working as part of a team here, but as a team within TDLR. We've had folks from Allies Against Slavery and Children at Risk and New Friends and New Life come to talk to our group. They did a tour of brothels in Houston, and it was eye-opening. One of the things that they taught me and I think they learned as well, but they taught me is that we have been seeing specifically the labor and the sex trafficking issue in massage. And I thought labor trafficking was only going to be in the nail salons. Well, on the tour, they discovered that there was sex trafficking taking place in the nail salons as well. And that was eye-opening to know that those places exist for this group. So I just wanted to introduce you to another piece of TLR's family, the Anti-Trafficking Unit. Thank you all for being here. Appreciate it. I'd like to touch very quickly on strategic planning. We received the instructions from the governor's office and the legislative budget board, and every agency in the state of Texas will be turning in their strategic plans effective June 1 of this year. It's a little earlier than we typically do. Normally it's like June 25th, sometimes July 27th are the dates that typically come to mind. So this moves our planning forward more aggressively. Mr. Chairman, doesn't change the depth of our planning. We've already had 2 meetings internally with our agency and talking to the folks that are helping me craft this new timeline. And a few things I just wanted to share with you that will be included in this strategic planning session. We are going to obviously turn the plan on June 1st. We're going to include 3 additional meetings into this process. So we're going to have our external meetings where we go around the state to at least 5 cities. We are going to have our very first ever completely virtual strategic planning session where everyone's going to be calling in and sending their information, and I'll be standing like right here in front of a green wall or something, trying to look like I know what I'm talking about. We're going to provide a mechanism, provide updates to the commission through the commission's work group, that is the Sunset, LAR, and Strategic Planning Work Group, chaired by Commissioner Callier, Callis, and Dr. Wesson are on that as well. We're going to do the online customer service survey. We'll hold the face-to-face with our employees as well. Every employee in TDLR is going to be able to participate. Mr. Chairman, we're also going to hold 3 unique sessions. One is going to be with the executive directors for the various associations of the industries that we regulate. We're going to have another session that's focusing on the criminal conviction guidelines and bring our partners in to have a conversation about that piece of the puzzle. We're also going to have a separate conversation about military spouses and veterans and how we can continue to improve in those processes. So those will be separate, unique components to the strategic planning process. And of course, we've also built in our dear friends with Sunset into our distribution of the information, because we're going to gather some information that they have not received yet. These questions will elicit a little bit of different response, and so we've made sure that we've incorporated them into the information distribution side of it to be a part of this process. But we'll give you more information at your next commission meeting, and we'll be updating you on that. And I need to bring Victoriano up here very quickly. This is the man who shuts off my computer when I don't do my training timely. Does it with a smile, though.
Well, like Kamala said, if I do my job correctly, you guys should never see me. So these are handouts on our cybersecurity awareness program that House Bill 3834 now requires all commissioners appointed or elected officials of state agencies comply with. On the 3rd page is a color-coded URL, and I'm not a marketing person, so it's not as fancy as it probably should be, but it starts with TDLR and it ends on .com. You enter that into your iPad's Google Chrome browser, and then you'll use your TDLR email address and TDLR passphrase or password to authenticate into this cybersecurity awareness training program. And there'll be 4 assignments, which are on the next page, listed 1, 2, 3, 4. They're pretty simple. They're anywhere from 5 to 20 minutes long. You guys actually get to do one of the ones that the staff hasn't yet done, which is the ransomware, protecting against ransomware.
Woo, that's exciting. That's exciting.
It is.
Easy.
And it's pretty simple. Now, at the very end of this presentation, if you will, I kind of used a bunch of red arrows to show you guys how to navigate, but it's pretty simple. But at the very end is my contact information and an email address that goes directly to myself and the cybersecurity staff. These folks are professionals. We don't sleep. We monitor that email 24/7. There's a phone number there too, and you guys can at any time call, email, and ask us any questions, and we can help you guys walk you through it.
When would you like the commission to have this done?
So the tool that we have puts a 1-month deadline. So you'll get an email from this third party, but it'll be called TDLR Information Security Office, and it'll come from that same email address. And it'll dictate a month either after today or tomorrow, as soon as you get the email. And so all the commissioners will get that in the next 24 hours. And then you literally just click in there, again, use your TDLR, and you have a month to go for it.
And this is requirements for who?
This is required for any appointed, elected, or staff member of any state agency. The company that we contracted with had to go through some homework with DIR first, and that's why I wasn't able to present in November, because we didn't have that stamp of approval yet from DIR. I got that literally the day after the commissioner meeting from DIR. So I'm here today to present that to you guys.
Okay. Everybody, any questions, commissioners? We have homework now. All right.
Mr. Chairman, I'll turn over to Christina Kaiser. I left off one of the roundtables. We're also going to do one on anti-trafficking to bring in those partners as part of our strategic planning process as well.
Christina?
Good morning for 5 more minutes. Mr. Chairman and Commissioners, I'm Christina Kaiser. I'm the Deputy Executive Director for Regulatory Services at TDLR. I would like to tell you about some promotions and new hires that have happened in the last couple of months. First, following my colleague David Gonzalez's promotion also to Deputy Executive Director, we promoted Charlotte Melder to his former director position. So Charlotte, who is in the room with us, is now the Director of Regulatory Program Management. Charlotte has been with TDLR since August of 2008 when she joined the Enforcement Division as a prosecutor. In the Enforcement Division, she served for 9 years as a senior prosecutor before she was promoted in 2018 to the section manager for business and consumer safety in regulatory program management. And she assumed her new position on December 1st, her director position. So congratulations to you, Charlotte. Following my promotion to a deputy position, we hired Ron Foster to serve as the new director of the Enforcement Division. Ron has been with the Enforcement Division since August of 2009 when he joined us as a prosecutor. In 2013, he was promoted to senior prosecutor, and then again in October 2018, he was promoted to chief prosecutor. In Ron's former life, he served in the United States Marine Corps from 1990 to 1995, and he also, prior to TDLR, he served the Department of Public Safety as a prosecutor in the Houston region. So congratulations to Ron. So as is often the case with promotions, dominoes fall. Following Charlotte's promotion to the director position, we needed to hire a new section manager for the Business and Consumer Safety section in RPM, Regulatory Program Management. Sorry, that's lots of words. For this position, we have hired Mr. Stuart Stenard. He comes to us from the Department of Agriculture, where he has been employed since 1998. And I'm sorry, I don't believe he's here with us today. He's at HR. Stuart has been with the Department of Agriculture since 1998, and for 11 of those years, he was in management roles. He started off as a field inspector, working multiple programs, including weights and measures, and he worked his way up to become the administrator of regulatory field operations. And in his most recent position, he administered 18 federal and state programs and supervised 175 staff members in 5 regional offices. And so we are happy to have Stuart on board with us. Similarly, dominoes continuing to fall. After Ron's promotion to the Director of Enforcement in the Enforcement Division, we hired another individual to serve as the chief prosecutor, who is the manager of all the lawyers. For that position, we have promoted John Medlock, who's also here in the room with us. John has been an attorney for over 12 years. He has been with TDLR for 6 of those years. He joined us as a prosecutor, and then for the last year, he has served as a senior prosecutor, a team lead type of position with the attorneys. During his time here as a prosecutor, John has worked cases on the building and mechanical team, where he has focused on cases involving air conditioning and refrigeration contractors, elevators, boilers, and similar types of programs. John also has quite a bit of experience doing public speaking engagements with industry groups in those professions. Prior to TDLR, John was with the Office of Inspector General at HHSC for 5 years, and he served as the lead for a team that litigated violations of the Medicaid program. John is also an adjunct professor with Texas A&M School of Law, where he teaches courses in public policy and Texas government.
Brilliant, man.
Absolutely. I couldn't agree more. I'd like a couple of other promotions in the Enforcement Division. Recently, Enforcement was given the authorization to create 2 supervisor positions in the legal assistance and administrative assistance group who support the lawyers. There are almost 30 people in this group, and for a long time they have been led by a single manager. So because of the growth in the group, we felt like there was a need for some another layer of supervision in there to help with quality control and training and those kinds of things. So I'm happy to announce 2 promotions. In that regard, we promoted Jackie Revilla, who has already been employed with the Enforcement Division. She's been with TDLR for a total of 17 years. For the last 6 years, she's been a team leader in the legal assistance section of the Enforcement Division. Prior to her time in enforcement, she also served in the executive office for 3 years. Brian was very bitter when she left them to come back to enforcement, actually. She also spent some time in the general counsel's office of TDLR. Prior to TDLR, she worked with the Real Estate Commission for 3 years and several other state agencies. For the other new supervisor position in the legal assistance section, we have promoted Debbie Hawkins. Debbie has been a legal assistant in prosecution for 7 years. Prior to that, she worked for 19 years as a senior paralegal with a law firm in private practice. In her former life, she served for 11 years in the Army. She was in a supervisory role with responsibility for up to 70 personnel. Debbie holds a paralegal certificate from the University of Texas at San Antonio and an advanced certified paralegal certificate from the National Association of Legal Assistants, which she obtained in January of 2006 and has maintained since then, just all on her own because she thinks it's a good idea. And finally, I'd like to introduce in the Field Inspections Division, we have hired Colleen Cloudy, I believe she's in the room with us, as the new lead facilitator. This was also a dominoes falling type of situation. The previous person in this position moved to, what is the group? The Optimum.
Yes, Optimum.
Yes. And so to refill her position, Tanya hired Ms. Cloudy. Ms. Cloudy comes to us from the Health and Human Services Commission, where she was part of the Business Integration and Support Team. She has a long history with HHSC. She began there as a frontline employee and worked her way up through various positions. Most recently, she has worked to establish best practices for analytics and workload statistics. In her current position, she will be responsible for division tasks such as performance measures, route optimization, and documentation of procedures. And we welcome Colleen to the team. Thank you. That concludes my report.
Thank you, Christina. It's always roses rise instead of dominoes falling. Roses rise.
Oh, much better. Thank you.
Congratulations to those that got promoted. We thank you for your effort. To those that are new to the family, welcome to the family. We lean in as an aggregate. If you ever need anything, we're always available to you. Great job, and excited about your new roles. Anything else, Mr. Francis?
Mr. Chairman, I think we're ready to go to dates and future meetings.
Right. All right, we're going to talk about our next meeting. Time would be April 7th. Is that right, Tamla?
Well, we have an option of April 7th, 8th, or April 10th. That's a Tuesday, Wednesday, or Friday. I will admit to you that Friday is Good Friday.
Stand by. So April 7th.
8th or the 10th.
8th. Or
I think we should take the 10th off the table.
okay. 7th works for me. Is 7th okay? I have it down as 7th. Does that stand by?
I'm good.
Good. 7th works.
I have one commissioner indicating that they are not available on the 7th.
Okay. Okay.
We've got a board.
We got a quorum? All right, so we'll set the meeting for April 7th. Does that work with the regs and everything else, Brian?
Yes, sir.
Okay, so we should be.
Pamela and Brad got together to kind of make sure that our meetings were staggered appropriately.
Just a meeting, okay. All right. All right, if there's nothing else, all right, I will entertain a motion to adjourn.
So moved.
Second?
Second.
All right, motion to adjourn.